mandatory. Yet the President, as a
Don't
measure,
skip any words. While
as a, I don't,
otherwise you will get a
I did not do it earlier and I'm not doing it now.
Yes.
Yet the President, as a measure,
Therefore, we are warning you not to do it.
yet the President, as a measure of prudence, ought to seek an opinion under the said provision in respect of bills that have been reserved for the consideration on grounds of perceived unconstitutionality. This is all the more necessary as there is no mechanism at the state level for the governor to refer bills to constitutional courts for their advice or opinion thereupon. Under the scheme of the Constitution, as we see it, there is only one possible way for the governor to ascertain the palpable constitutionality of a bill, which is by way of reserving it for the consideration, who in turn is expected to invoke 143. The Constitution is not a maze, but a labyrinth. Although both may semantically appear to be one and the same, yet there is a fine but discernible difference between the two. The difference lies in the fact that in a maze, one may lose their way within the multiple overlapping paths, with the possibility of each of them leading to a dead end. However, in a labyrinth, one eventually finds the way and in the process also comes out more enlightened. So if she wants enlightenment, of course she can come. Similarly, any questions emanating from the Constitution or pertaining thereto, such as constitutional vagaries of a law, must be uncovered through the foresightedness of our Constitution. Whenever a bill is reserved for the governor, by the governor for the President, on the ground of patent unconstitutionality of the nature wherein the exercise of discretion by the governor is permissible, the Constitution expects the President to be the soothsayer, easing the sails for the governor. The invocation of the power of the reference in 140.
Where is the operative part? The direction.
Yes, para 20. Come to para 20. Para 20.
Please read it.
Yes, 12575. Para 20.
Yes, please read it.
Whenever in exercise of the powers under 200, a bill is reserved for the consideration of the President on grounds of patent unconstitutionality that are of such a nature so as to cause peril to the principle of representative democracy, the President must be guided by the fact that it is the constitutional courts which have been entrusted with the responsibility of adjudicating upon the question of constitutionality and legality of an executive or legislative action. Therefore, as a measure of prudence, the President ought to make a reference to this.
Ought to make a reference.
Ought is there, I mean, Your Lordship, may I say straight away, it may take not a minute of Lordship's time. My case is that.
If you consider that, that's the end of the
My
matter.
case is that. I started by saying so.
Then why unnecessarily have a debate?
I wanted to say that my reading of this is also that it's an option given. But the Lordship may now clarify. Lordship may clarify. The matter ends.
And this observation that anyway, let's not go into that.
Para 141 is a similar sentiment in 1978 Special Courts Bill. It's not that just the division bench plucked it out of nowhere. A constitution bench at 141 had a similar sentiment. Lordship should know the entire history in a constitutional reference. See what they say. It may not be necessary or even advisable to adopt such a course in all references under 143. But if in some it becomes expedient, as in my opinion in the instant case, I think it saves a lot of public time and remove any technical lacuna, etc. That's an option given to your Lordships. Now let us come to questions, page 140. 10, 11 and 13 dealt with together. Page 140. 10, 11 and 13. 10 is the 142 question. Eleven is framed at 140, is a law by the state, a law enforced without the assent of the governor. And 13 is to the powers of the Supreme Court under 142 limited to matters of procedural law, etc. Now, this is important. 142 has been misunderstood. It is in fact one of the few articles which passed without discussion, as well as a clear power entrusted to the body which had maximum trust, accepted by all without controversy. Two amendments were moved. Two amendments were cited, never moved. Never moved. Come to that, please. 142, I'll just read through it. Para 145. 142 empowers the Supreme Court with unfettered, limitless and self-restrained powers. Mark the word self-restrained. When I say limitless, it doesn't mean no self-restraint. To do complete justice in any matter or cause, Considering the very wide ambit, the same is used sparingly and only in those cases where it is necessary to complete justice. The power is one of self-restraint. Ordinarily, it cannot circumvent and disregard a statutory provision governing a field, with the exception of doing substantive justice. Now, there is 5 judges in this Supreme Court Bar Association. Just read that. The very insignia of the complete trust in the apex body, which the entire constitution, there are very few articles which have passed without.
So, in the facts of the case,
that's
can
coming.
he lay down a timeline under 142 to do complete justice?
Yeah.
Can he lay down a straitjacket formula for exercise of the powers by the governor and the president while exercising 142?
Suppose, Balas, it is coming here. Suppose your lordship has a statute, forget a constitution, which indirectly impinges. My lords may have a rethink whether you will pass a direct order under 142 touching that statute. Suppose my lord has a clear implicit in some other article that your lordship should not touch 200 with a time limit. It's inexorable. Your lordship may not use 142. Barring that, this is a question not created by us, it's a question referred by the president, by the government. Is there a fetter on your lordships in 142 in such a situation? Is the question. I have not referred the question. This question is raised to create another limitation of some kind. Now let us kindly come to 149. Now this is an interesting judgment, which is when there are 2 constitutional provisions clashing. 142 and another existing provision. This is very interesting, Balas. Your lordship has gone to the extent of saying when 142 and a provision are clashing, when the matter is sub judice, 142 will prevail. Just see that. 2 minutes.
How much time will you take on this?
15-20 minutes after lunch, I'll finish.
We'll begin at.
Oh, I see. I didn't know. I'm sorry.
What is likely to take 10-15 minutes?
Oblige.
You have 2 more days left, and we'll adjust 1.5 hours, which the learned solicitor to the
2.5 days more.
No, 1.5 hours. So 2.5 days we include today.
Today is the second day.
Today's second day, 2 more days, and then whatever time you took, 1 hour or 1.5 hours.
1.5 hours, exactly.
We'll compensate.
That will be the third day afterwards, which will be 1.5 hours extra. We have enough time, Alice.
And we'll curtail the time from the rejoinder from that.
Your lordship is now acting like the American courts, Alice.
మీరెళ్ళి బండిలో కూర్చోండి, ఇతను వస్తాడుగా.
పంపించేయండి.
కొడుకు
ఎల్లమ్మా ఎల్లో, అమ్మాయితో వస్తాను.
సరే బంగారం, త్వరగా వచ్చేయ్.
చెప్పాడుగా, వెళ్ళండి.
అమ్మాయితో వెళ్తావా? ఎల్దు గాని ఇంతవరకు ఎంతమంది అమ్మాయిలు చూసారు మీరు?
10 అడుగులు అయిపోయారు, ఇది 18వ.
వీడో పెద్ద గజనీ మొహమ్మద్ ఇలా దండయాత్రలు చేస్తున్నాడు. వెళ్ళిన చోటల్లో అమ్మాయిని రిజెక్ట్ చేసినా లేదా నువ్వు అమ్మాయిని రిజెక్ట్ చేసావా?
అమ్మాయిలే రిజెక్ట్ చేశారు.
మరి ఏ మొహం పెట్టుకొని మా ఇంటి అమ్మాయిని చూడటానికి
మీ
వచ్చి?
ఇంటికి పెళ్లి చూపులకి చాలా మంది వచ్చి వెళ్ళారని తెలిసిందే, అందుకే నేను ట్రైల్ వేద్దామని వచ్చాను.
నువ్వు ట్రైలర్స్ చూడడానికి నా చెల్లెలు ఏమన్నా స్కూటీ అనుకున్నావరా? మల్లె పువ్వు లాంటి నా చెల్లెలు ఎక్కడ, కందిరేగ లాంటి నువ్వెక్కడరా? పగలు చూస్తే రాత్రి కల్లో కోసం నీకు మా చెల్లెలు కావాలా? అన్నా వెళ్ళి మీ పని చూసుకోండి, వీడి పని మేము చూసుకుంటాం. తడి చేతిలో వేయాలా, పొడి చేతిలో వేయాలా, ఏదో ఒక దాంట్లో వేద్దాం.
బెళ్ళంతా రెడీ చేయరా?
అలాగే మావా.
చెల్లెమ్మకు బెళ్ళంట, అన్నయ్యకు సంబరమంట. మేడ మీద బర్డ్స్ కేయడానికి.
ఇప్పుడు వెళ్ళే కాకులు గుడ్ల గోబులు వాటి కోసమా?
అవును.
ఒరే వాస్కో, అంత పెద్దోడు వైపేవా?
ఏమైందమ్మా?
చలివేంద్రం తెరవటానికి నిన్ను పిలుస్తున్నారు. ఇదిగో ఫోన్ మాట్లాడు.
అక్కడికే వస్తున్నాను చెప్పమ్మా.
బాబు
మాతృదేవో
అక్కడికే
భవ.
వస్తున్నాడట. రేయ్, ఏదో ఒక రోజు నువ్వు తప్పకుండా దొరుకుతావు రేయ్.
నిన్న ఒక జోసుడి దగ్గరికి వెళ్ళాను. ఆపడానికి వీలొద్దా అని అడిగాను. చాలా మంది ట్రై చేస్తారు కానీ వీలు కాదు అన్నాడు.
ఏంటది?
వయసునే, ఉన్నంతకాలం హ్యాపీగా ఉంటాను, వదిలే. వస్తాను.
నీ
నా
తల
బంగారు తల్లివే.
రే 2 సీసీ కెమెరాలు ఉన్నాయి, చూసి చూడనట్టు పైకి వెళ్దాం.
అంకుల్ ఏంట్రా సంచిలో?
ఏం లేదు అంకుల్, ల్యాప్టాప్ చందుతో అప్డేట్ చేయాలని రమ్మన్నాడు.
వెళ్ళు. ఏంటలుడు
మాయా,
సంచుల్లో ఏమున్నాయి?
మాయా స్నాక్స్. మాయా
స్నాక్సా?
అవునత్తయ్య.
ఏమన్నాయా కాస్త చూపించు.
చూడండి, అన్నపూర్ణ స్వీట్స్ అండ్ కారం, బెజవాడ పెద్ద బ్రాండ్ అత్తయ్య, బాగుంటాయి. మావయ్య ఇంత ముందు ఎవరైనా బ్యాగ్ తో వెళ్ళారా?
అవునలుడు, ల్యాప్టాప్.
ఆ ల్యాప్టాప్ కోసమే మావయ్య మిక్చర్.
అలాగా?
ఫ్రీ అయితే టెర్రస్ రండి మావయ్య, మనం మిక్చర్ తింటూ ఫ్యూచర్ గురించి డిస్కస్ చేద్దాం.
సరే అలుడు,
మర్చిపోకండి మావయ్య.
వస్తానుగా.
మీరు రాకండి అత్తయ్య.
ఏమండి, వాళ్ళు మందు కొట్టి చెడిపోతుంటే మీరైనా కాస్త బుద్ధి చెప్పాలి కదా.
బుద్ధి చెప్తానే, నాకొచ్చే కోపానికి 5 ఆమ్లెట్లు, 5 ఆఫ్ బాయిల్డ్, పెప్పర్ ఎక్కువ వేసి పట్రాపో.
చలివేంద్రం తెరవాలని ఎవరా చెప్పింది? ఇదిగో పట్టుకో.
రానా కూర్చో.
నువ్వెందుకు చలివేంద్రం తెరవడం? ఏ చెప్తే గాని తాగవా? అది కాదు,
చెప్పడానికి వీలు కాదు, పోరా.
తమాషాగా చెప్తున్నావా?
లేదు, వాడు సీరియస్ గానే చెప్తున్నాడు.
సీరియస్ గా చెప్తున్నాను, పోరా.
తాగడానికి కారణం ఉండాలిగా.
ఎందుకు కారణం కావాలి? లాక్ డౌన్ లో మందు దొరకదని స్పీడ్ తాగినోడ్రా వీడు, చచ్చుండేవాడు. వీడు కారణం అడుగుతున్నాడు. సిగ్గు లేదా, రోషం లేదా, చీవు లేదా, నెత్తురు లేదా?
దాన్ని అక్కడే పెట్టి వెళ్ళాలనిపిస్తుంది.
రేయ్, మీరందరూ ఎవర్రా?
ఎవరు?
నా ఫ్రెండ్స్ రా. మీరు ఉమ్మేసి ఇచ్చినా కూడా తాగుతాను రా. ఉమ్మై
కింద పెట్టు. అనవసరంగా వాకుండా మొదలు పెట్టా. మొదలు పెట్టండి.
రాములో రాములా నన్నాగు.
చంద్రు, మహేంద్ర కంపెనీలో జాబ్కి వెళ్ళావు కదా, ఏమైంది?
కంపెనీనా?
కొంచెం రైట్ లో చూడరా, మీ నాయన వచ్చారు.
యా, ఐ అప్లైడ్ ఫర్ ద CEO.
ఓవర్ యాక్షన్ చేయొద్దురా. ఓ సుపుత్ర, ఆ తాగేదేదో ఇటు తిరిగి తాగరా. రే ప్లేట్ ఇవ్వరా, అది కూడా ఇవ్వు. అల్లుడు, ఇవాళ ఏం బ్రాండ్ తాగుతున్నారు?
రమ్మయ్య, మీరేగా తాగమన్నారు.
అల్లుడు, అప్పుడైతే వింటరు రమ్ము తాగమన్నాను. ఇలాగే దొరని నా ఫ్రెండ్ అడ్డమైన మందు తాగి చిందులేసి చివరికి మగతనం పోగొట్టుకున్నాడు.
మావయ్య మ్యాటర్ అర్థమైంది మావయ్య.
అర్థమైందిగా, ఇంకేమైనా కావాలా?
కిందకి వెళ్ళిపోండి మావయ్య, ఏదైనా కావాలంటే చెప్తా మావయ్య.
ఓకే,
నమస్తే.
అంటే మనం ఇక దేనికి పనికిరామా?
నన్నెందుకు కలుపుతున్నావు, జుట్టు పొలిగాడా? రేయ్
కోపడు కన్నా, అదే మగతనాన్ని పెంచుకోవడానికి ఏవేవో మూలికలు మందులు వచ్చాయి కదా, వాటిని వాడతానులే.
ఇలాంటి నాన్న నాకుంటే 24 గంటలు తాగుతూ ఉంటారా?
మీ బుర్రలో బుల్డోజర్ దూరా తాగద్దని ఇండైరెక్ట్ గా చెప్తున్నారా? నాన్న సారీ నాన్న.
ఏమే, ఎగ్ బూజీ ఒకటి చేస్తావా?
వేడి నీళ్ళున్నాయి, మొహన కొట్టమంటారా?
ఊరికే అరో మాకు. నీకు అర్థమైందో లేదో గాని వాళ్లకు బాగా అర్థమైంది. బారులో తాగి రోడ్లో దొర్లి గొడవలు పడి సమస్యలు తెచ్చుకునే కంటే మేడపై తాగుతున్నారు కదా, ఉదయాన్నే లేచి వాళ్ళ ఇంటికి వెళ్ళిపోతారు. పిల్లల ప్రాణాలు ముఖ్యం కదటి.
మీరెట్టు అడగరు గాని నన్ను అడగమంటారా?
ఓసే నాంచారి, ఇప్పుడే వెళ్లి వాళ్ళని అడగవే. కూలింగ్ బీర్లు తెచ్చుకుని రేపు కూడా జాలీగా తాగుతారు.
కూలింగ్ ఉందిగా. 1 2 4
చూసుకొని పోరా.
చూసి బండి నడిపోయా. బాటిల్ బాగుంటే నీ బుర్ర
సైడ్ డిష్ తీసుకోలేదా?
సైడ్ డిష్ ఎక్కడ తీసుకోవాలో ఎప్పుడు తీసుకోవాలో నాకు తెలుసు.
అన్నిటికీ ఎందుకు ఇలా వాగుతుంది?
తిన్నగా పోని.
ముదిరిందిరా.
నీ తమ్ముండేక చల్లటి పేరు గొంతులో దిగుతుంటే ఉంటుంది నా సామిరంగా.
చెప్పండి బాస్, ఏం కావాలి?
పెద్దవాళ్ళని పిలువమ్మా.
ఏంటి?
చిన్న పాప లోపలికి వెళ్ళు.
మోహన్ చూడు.
ఓ లోపలికి నువ్వు వెళ్ళారా? అన్నపూర్ణని పిలువు.
అంటే దానికోసం వచ్చారా?
రమ్మని
ఏ
చెప్పు.
అన్నపూర్ణ, నిన్ను వెతుక్కుంటూ ఇద్దరు క్లయింట్స్ వచ్చారు చూడవే.
ఇద్దరు కాదు ఒక్కరే. ఈ మామ నీ కోసం వచ్చాడు.
ఏం కావాలి బాస్?
స్టార్ట్ చేయాలి.
2 డిస్పో గ్లాసులు, 2 ఊరగాయ ప్యాకెట్లు, చింతామణి చికెన్ 1 ప్లేటు, 2 ఆబాయిలు పెప్పర్ బాగా వేసి కూలింగ్ తగ్గక ముందే తీసుకురా. పో పో పో.
హలో, కళ్ళద్దాలు తీసి చూడండి, ఎక్కడికి వచ్చారో తెలుస్తుంది.
వేరే చోటుకి వచ్చామా?
రేయ్, స్వీట్ స్టాల్ రా.
రే రే రే
చూడమ్మా, నవ్వుకుంటాం.
తగ్గండ్రా.
బాగా అనుకున్నావులే.
రేయ్, ఇక్కడ ఎవరు తాకూడదు, వెళ్ళండి. ఈ చెత్తను తీసుకెళ్ళండి.
అయ్యో మా అన్నిచ్చిన డబ్బులన్నీ నూరంగా మారిపోయాయే. అయ్యో ఇప్పుడు ఏం చేయాలి? అయ్యో ఈ బ్రాండ్ మళ్ళీ దొరకదే. దొరికినా కూలింగ్ ఉండదే. ఈ ఎండలో ఏం చేయాలి?
అయ్యో ఏంటి ఇది?
మీ అమ్మాయి ఎలా పగలగొట్టేసిందో చూడండి
అమ్మా, బియర్ అమ్మా.
బీరా? అయ్యో ఏంటయ్యా ఇది? షాప్ లో బీర్ బాటిల్స్ అన్ని పగలగొట్టి డ్రైనేజ్ చేసావు. వీటన్నిటిని తీయవయ్యా, నీకు దండం పెడతాను.
ఏంటి డ్రైనేజ్ చేసేనా?
పడదు, ఈ గబ్బు పడదు.
ఏంటమ్మా సౌండ్? కస్టమర్లను మెయింటైన్ చేయలేకపోతున్నావా? ఏంటి బీరు ఎంత నొరగ్గా ఉంది? ఓరే దుర్మార్గులారా, స్ట్రాంగ్ బీర్ని ఎవర్రా పగలగొట్టింది?
నొరగని చూసి అది స్ట్రాంగ్ బీరా లెగర్ బీరానికి ఇట్టే కనిపెట్టేశారే. దాంట్లో పీజీ చేశారా, పిహెచ్డి చేశారా?
బాబు, బొగ మంది నొరగొస్తే అది స్ట్రాంగ్ బీరు, లబక్ మంది నొరగొస్తే అది లెగర్ బీరు.
సూపర్ సూపర్.
ఎక్కడికో వెళ్ళిపోయారు.
బాగా చెప్తున్నారే, మీరు తాగుతారా?
ఊరుకోవే, తాగుబోతుల గురించి చదివాను. చదివితే తాగినట్టు అర్థమా?
తాగుండేనమ్మా, తాగుండే. తాగుంటే ముగ్గులు బూరెల్లా ఊరుండేవమ్మా. మీ ఆయన రాముడు, నిందలు వేయకమ్మా. ఈ తాగుబోతు మాటలు నమ్మమ్మా.
అయ్యో నా జీవితం
అయ్యయ్యో.
నాశనమైపోయింది. మీరు మంచోళ్ళు.
అమ్మా,
నాకు
మీ గొడవ తర్వాత పెట్టుకోండి అమ్మా. ఇంట్లో పెట్టుకోండి. నా డబ్బు 1050 ఇవ్వండి.
గల్లా పెట్ట డబ్బు తీసిచ్చాయి.
నాన్నా, క్యాష్ బాక్స్ లో క్యాష్ లేదు.
అలా తెల్ల మొహాలు ఎక్కడే, నా డబ్బు నాకు ఇవ్వండి.
ఏంటమ్మా ఇది?
ఇలా చూడండి, మీరు ఎందుకు ఇలా గొడవ చేస్తున్నారో, ఎందుకు ఫాలో అవుతున్నారో నాకు బాగా తెలుసు. నాకు ఆల్రెడీ ఒకడున్నాడు, చెప్పాను, బ్యాగ్ ఆడతాడు.
నువ్వు అసలు మారనే మారవా? రే, గొడవ పెట్టుకోరా.
రే రామస్వామి, మునుస్వామి, ఆసామి, ఈసామి, అందరూ రండ్రా.
ఆగరా.
మీకు కావాల్సిన డబ్బేగా, పక్కనే ఒక ఏటీఎం ఉంది, తీసిస్తాను. ఫాలో మీ.
సార్, నా మీద ఎలాంటి తప్పులేదు సార్. మీ అమ్మాయి సార్ ఫాలో చేయమంటుంది.
ఫాలోనే కదా, ఫాలో అవ్వండి.
అల్లుడు,
అయ్యో అమ్మా,
ఇక్కడ పైన చూడు. ఎక్కడికి వెళ్తున్నావు?
మావయ్య అటువైపు వెళ్తున్నాను మావయ్య.
అదే ఎటువైపు వెళ్తున్నావు?
అటు పక్క పని ఉంది మావయ్య.
ఏ పని మీద వెళ్తున్నావు?
పని మీద అని చెప్తున్నానుగా మావయ్య.
అదే ఏ పని మీద అని అడుగుతున్నాను కదా.
మావయ్య తెలిస్తే చెప్పనా మావయ్య? మీరు ఎక్కడికి వెళ్ళాలి?
ఉండు, ఇదిగో వస్తున్నాను.
ఈయనున్నాడే, రండి.
అల్లుడు, తోట వరకు వెళ్ళాలి, కాస్త లిఫ్ట్ ఇవ్వయ్యా.
కూర్చోండి.
ఇదిగో కూర్చుంటున్నా.
ఇంత వయసు వచ్చిందే, అడగగానే చెప్పాలని తెలీదా?
లేదు అల్లుడు, దగ్గరకు వచ్చి చెప్దామని.
ఏ రోజు చెప్పారు.
అన్నం కూడా తినకుండా వెళ్తున్నారు చూడు.
అదే అల్లుడు, మన సుమతికి సంబంధాలు కుదరట్లేదని మీ నాన్న చెప్పాడు.
అవును మావయ్య.
నేను ఓ సంబంధం చూశాను.
అబ్బాయి మంచోడేనా?
అవును అల్లుడు, చాలా బుద్ధిమంతుడు.
ఏం చేద్దాడు మావయ్య?
మెకానికల్ ఇంజనీరింగ్ పూర్తి చేశాడు అల్లుడు.
మెకానికల్ ఇంజనీరా?
అవునా?
అయితే మొండి ఘటమే. ఉద్యోగం దొరుకునేదే పాపం.
అది నిజమే, ఉద్యోగం దొరకలేదు, కానీ తొందరలో దొరుకుతుంది. కానీ అమ్మాయిని మాత్రం పువ్వుల్లో పెట్టుకుని చూసుకుంటాడు అల్లుడు.
మావయ్య, ఇప్పటికీ నువ్వు చెప్పాలనుకున్న విషయం చెప్పలేదు మావయ్య.
అల్లుడు
చెప్పండి.
సుమతి మా ఇంటికి కోడలుగా రావాలని మా ఆశ. అది మీ నాన్నతో ఎలా చెప్పాలో తెలియట్లేదు. అందుకే
మావయ్య, చందు మా ఇంటి అల్లుడవుతానంటే అంతకుమించి మాకు ఇంకేం కావాలి? అమ్మ నాన్నతో మాట్లాడి, మా చెల్లెలతో మాట్లాడి చెప్తాను మావయ్య.
చాలా సంతోషం.
సంతోషం మావయ్య.
వస్తాను అల్లుడు. ట్యాంకు పోయినా మార్చుకోవచ్చు. హెల్మెట్ తీసి తలకు పెట్టుకో, సేఫ్టీ ముఖ్యం కదా.
సరే మావయ్య.
అల్లుడు, నువ్వు గొప్పోడు అవుతావు అల్లుడు. అది తెలియక ఊరంతా తిరుగుతున్నావు.
ఇప్పుడు మీరేమైనా అంటారులేండి.
బండి తీరా. ఇవన్నీ ఎండిపోయాయి. మనోళ్ళు ఎక్కడ తెచ్చారో నీళ్లు వదలలేదనుకుంటాను. మోటార్ కూడా పనిచేయడం లేదు. ఏం పని చేస్తారో ఏంటో. ఏవయ్యా రంగయ్య, ఎక్కడున్నావయ్యా? త్వరగా రావయ్యా. ఏయ్, ఎవరయ్యా నువ్వు?
నేను రామయ్య కొడుకున్నా.
అయితే
రేడియేటర్ హీట్ ఎక్కి బండి ఆగిపోయింది.
ఓ అలాగా,
తీసుకెళ్దామని వచ్చిన.
మోటార్ రిపేర్ అయింది, తోడుకుని వెళ్ళు.
సరే
వెళ్ళు. ఏయ్, నువ్వెవరయ్యా?
రేడియేటర్లో నీళ్ళు లేవన్నా, అందుకే తీసుకెళ్దామని.
మరి వాడు కొత్తమ్మల్లారా, తప్పించుకొని ఉంటే మన ప్రాణాలు.
సార్, చివరికి తెలుస్తుంది.
ఆయన కూడా
పొద్దున బైక్ లో తీసుకెళ్ళింది నువ్వే కదరా? ఎందుకు తీసుకెళ్ళావు? ఎక్కడికి తీసుకెళ్ళావు? స్టేషన్కి తీసుకురండి. అరుస్తున్నావు, చెప్పు.
సార్, గుడ్ల రవి సార్.
గుడ్ల రవి హత్య చేయటం నువ్వు చూసావట్రా?
మరి నేను చంపడం నువ్వు చూసావట్రా?
ఇన్స్పెక్టర్ నే రారా పోరా అంటావా? ఎంత పొగర్రా నీకు?
నేను పోరా అంటే నీకు కాలుతుంది కదా, మరి నువ్వు పోరా అంటే నాకు మండరా?
వీడిని బండి ఎక్కించండి.
మండరా?
ఏమనుకుంటున్నారు సార్ మీరు? హంతకుడిని వదిలేసి మావోడిని పట్టుకెళ్తారేంటి?
వెళ్ళి హంతకుడిని పట్టుకోండి సార్.
యాక్షన్ తీసుకోలేదు, శవాన్ని రోడ్డు మీద పెట్టి ఆందోళన చేస్తాం.
అవును.
You don't need a second job. You just need to learn how to talk to AI.
Let's be real. Most people over 40 use ChatGPT.
రా బాబు, వెళ్ళి ముందు హంతకుడిని పట్టుకోండి సార్.
నమ్మబుద్ధి కావట్లేదే. ఏదైనా నాకు చెప్పే చేస్తాడే. రేయ్,
అయ్యా.
రవి ఎక్కడ?
అయ్యా, రాత్రి పని మీద బెంగళూరుకు వెళ్ళారయ్యా. ఫ్యాక్టరీ విషయంగా మీరే కదా బెంగళూరు పంపించింది.
ఆడొచ్చాక నేనే మాట్లాడతాను, మీరు ఇక వెళ్ళండి.
గుడ్లు రవి వస్తే ఓసారి స్టేషన్కి రమ్మని.
అదే నేను మాట్లాడతానన్నాను కదా, మరి ఇంకెందుకు స్టేషన్కి రమ్మని చెప్పేది? విజయవాడలో కుక్క చచ్చినా కూడా దానికి కారణం గుడ్ల రవి అంటారా? ఇప్పుడు మీకేం కావాలి? ఈ కేసు ఫినిష్ అవ్వాలి, అంతేగా? రేయ్, ఇటండి, వీళ్ళతో కేసు ఫినిష్ చేసుకోండి. రేయ్, అయ్య గారితో వెళ్ళండి రా.
వస్తాం సార్.
రేయ్, ఎక్కండి రా బండి.
అదంతా వద్దు, మీరు వెళ్ళండి. మీరు బండి ఎక్కండి.
లోపలికి వెళ్ళండి రా.
వేడిగా ఉన్నాయి, తిన్నానయ్యా. తింటానులేరా, నువ్వు కూడా కూర్చొని తిను. వాడికి కూడా వెయ్యి. ఏంట్రా, ఏంటి గొడవ? ఇన్స్పెక్టర్ వచ్చి వెళ్తున్నాడు.
మరేం లేదన్నయ్యా, ఆ లెదర్ ఫ్యాక్టరీ స్థలం ఉందే, అదో ట్రస్ట్ది. ఆ ట్రస్ట్లో ఉన్న 12 మంది సంతకాలు చేశారు. వీడు అక్కడే సంతకం చేయనని మొండికేశాడు. అందుకే లేపేశాను. ఇంకో వారంలో వాడి డెత్ సర్టిఫికెట్ వచ్చేస్తుంది. ఆ తర్వాత ఆ సైట్ మందే.
మా చెప్పమ్మా.
ఎక్కడున్నావురా?
పక్కనే ఉన్నాను, చెప్పు.
వెంటనే ఇంటికి రా.
రారా, అమ్మాయిని చూడటానికి వచ్చారు.
ఆషాఢం అయ్యాక అమ్మాయిని అడగడానికి వద్దాం అనుకున్నాం. ఈలోపు ఎవరన్నా వచ్చి సంబంధం కుదుర్చుకుంటే అందుకే మేము ఇప్పుడే వచ్చేసాం.
నాన్నగారు ఉన్నప్పుడు చెప్తూనే ఉన్నారు మామ, మనం వెళ్ళి అమ్మాయిని అడుగుదామా అని. కానీ మీరు తప్పుగా అనుకుంటారేమో అని ఆయన మీతో చెప్పలేదు మామ. మామ, నేను ఇంకెప్పుడు తాగను మామ. సుమతిని చాలా బాగా చూసుకుంటాను మామ. వైజాగ్ టీవీఎస్లో ఇంటర్న్షిప్ వెళ్తున్నాను మామ. 2 నెలల్లో జాబ్ కన్ఫర్మ్ అవుతుంది. అపాయింట్మెంట్ ఆర్డర్ కూడా వచ్చేసింది మామ.
పళ్ళెంలో బియ్యం చేరు మేనా మామ సారే గుడ్ మాము
మొత్తం
చేస్తాం
చూడాలి కదా.
అయితే అయిపోయే వాళ్ళం.
చూసి రబ్బట్టారా ప్రాణాలతో ఉన్నారు.
ఒక క్షణం లేట్ అయితే అయిపోయే వాళ్ళం.
బ్రేక్ అయిపోతే 108 నేను రాంగ్ రూట్ లో
విజయవాడలో
ఏంద్రా ఎవరో తెలియదు నలుగురు వచ్చే
లోపలికి రారా.
ఏ లేదు రవి విజయవాడ బస్ స్టాండ్ లో చూడు
మనోళ్ళే చూసొస్తాను.
నువ్వు బ్రిగాన్ వారా?
తెలియకుండా చేసేవాడు.
సుత్తి కింద పడేరా, తీసుకురండి అయ్యా. రారా
సార్ వదలండి సార్. సార్ వాడే సార్ మమ్మల్ని కొట్టాడు. మమ్మల్ని సార్ అరెస్ట్ చేశారు.
సార్ ధైర్యం ఉంటే గుడ్ల రవిని అరెస్ట్ చేయొచ్చు కదా సార్. ఇద్దరం కలిసే కదా గొడవ పడ్డాం.
మాట్లాడావో పళ్ళు రాలగొడతా. ఇప్పుడు చట్టం అది ఇది అన్నావు. ఎవర్రా మీరు?
ఏంటి సార్ తెలియనట్టు మాట్లాడుతున్నారు? రవి అన్న పంపించాడు.
లోపలికి ఎందుకు వచ్చారా?
చేస్తాడా తమ్ముడు ఎవడో చూద్దాం
పిలుస్తుంటే అటు వెళ్తావేంటి?
సార్ అన్నం మీద చేస్తావా? బయటికి రారా, నీ అంతు చూస్తా. అరే మనోడే సార్, అన్న చెప్పాడు కేసు ఏం ఫైల్ చేయకండి.
కేసు ఫైల్ చేయడం అయింది, ఏం చేయాలో మాకు తెలుసు. పోరా బయటికి.
కేసు ఫైల్ చేశారా?
పోరా బయటికి.
నిజంగానే?
పోన్రా బయటికి.
ఓకే సార్. యారా అన్న మీద చేసుకున్నారే, ఈ కుర్రాళ్ళది ఏ ఏరియా?
సర్కిల్ అన్నా.
అలాగా?
వాడి కేసు వద్దంటున్నాడు కదా సార్, మమ్మల్ని వదలండి సార్.
నిన్నెందుకు బయటకు పంపించమన్నాడు తెలుసా? పూలమాల వేసి ఘనంగా సత్కరించడానికి కాదురా, నిన్ను లేపేయడానికి. నీ మీద కేసు పెట్టి కోర్టుకు తీసుకెళ్తే నిన్ను మధ్యలోనే నరికేస్తారు. నీకు ప్రాణం పోతుంది, నాకు ఉద్యోగం పోతుంది. ఒక మాట చెప్తాను విను, వెళ్ళి గుడ్లు రవితో రాజీ చేసుకో. లేకపోతే స్టేషన్లో రాసిచ్చేసి రాత్రికి రాత్రే ఊరు వదిలి జంప్ అయిపో. నీ మీద కేసు ఫైల్ చేయలేదు, ఎందుకో తెలుసా? గుడ్లు రవిని నేనే కొడదామనుకున్నాను, అది నా వల్ల కాలేదు. నువ్వు కొట్టావు చూడు, అందుకే ఈ చిన్న హెల్ప్.
అంకుల్, ఈయన 6th వార్డ్ కౌన్సిలర్ గారు.
నమస్కారం.
గుడ్ల రవికి సన్నిహితులు.
నమస్కారం.
ఈయన మాట్లాడతానన్నారు.
తమ్ముడు జరిగిందంతా చెప్పాడు. మీరు సాక్షి కాళ్ళ మీద పడ్డం కంటే గొడవ పడ్డ వాళ్ళ కాళ్ళ మీద పడ్డమే మంచిది. గుడ్ల రవి సమస్య తీరాలంటే మీరు ఆ గుడ్ల రవినే కలవాలి.
తెల్లారుజామున పెళ్లి. వెళ్దాం రండి.
సరే రండి వెళ్దాం.
మదని
నువ్వు ఎక్కడికి వస్తున్నావురా?
తోడుగా వస్తాను.
కొట్టింది చాలదా మళ్ళీ వస్తున్నావు? నువ్వు బైపాస్ లో ఉన్న అత్త వాళ్ళ ఇంటికి వెళ్ళు. నేను ఫోన్ చేసినప్పుడు కళ్యాణ మండపానికి రా.
రవితో
Are you an aspiring entrepreneur? Are you interested in selling your products on Amazon? If yes, I invite you to my 3 days Amazon selling workshop. In this
నిన్ను కలవడానికి 6వ వార్డు
మీరు ఇక్కడికి ఎందుకు?
వాళ్ళ నాన్న
ఇంత ఆవేశం పనికిరాదు.
నన్ను వదలన్నా. వదిలేరు. ఎందుకు ఇలాంటి వాళ్ళని మీరు తీసుకొచ్చారో? అన్నా ఇలా రండి. విజయవాడలో ఏం చేస్తుంటారు? పూల వ్యాపారమే కదా. నేనేం చేస్తుంటానో తెలుసా? దాదాగిరి. అడ్డొచ్చిన వాళ్ళని పడాలి. అది కాదు, ఆడవాళ్ల మీద చేయి చేసుకునే అలవాటు నాకు అసలు లేదు. వాళ్ళ అమ్మాయి పెళ్లిని చేసుకోమనండి.
నేను అడ్డు రాను, కానీ నీ కొడుకుని చంపుతా. నీ కొడుకు తలని నరికేసి విజయవాడ బస్టాండ్లో వేలాడదీస్తా. పో పో.
కంట్రోల్ మిస్ అయిందా? తాళ మీద
సారీ అండి.
ఏం పడిందో చూడవే. అమ్మా ఏంటిది?
మాట్లాడు పాస్ అవుతావా?
పట్టి పడి అంతు చూస్తాను సార్.
చెప్తున్నావు ఊరిగా మాట్లాడు.
సారీ అండి.
ఏమయ్యేదో తెలుసా?
ప్లీజ్
ఇవ్వం పో.
డ్రోన్ తో షూట్ చేయడానికి పర్మిషన్ ఉందా?
లేదు సార్. షార్ట్
లోపలికి రండి. లోపలికి రండి రా. ఒక్కడు కూడా లేదు సార్. వాస్కోడా గామా డిఎస్పి
కండవిటి సింహం.
ఏంటిది?
24 అవర్స్ లా అండ్ ఆర్డర్ డ్యూటీ. జస్ట్ రిలాక్సేషన్ సార్. ఇప్పుడే సమంత పాటేశాను, అందరం ఎంజాయ్ చేస్తున్నాం.
ఆఫ్ చేయవా అది?
సార్ ఇందులో చిన్న సమస్య ఉంది. ఆఫ్ చేస్తే మళ్ళీ ఆన్ చేయడం.
ఆఫ్ చేయవా? స్టేషన్ లో ఇంతనే ఇంకెవరైనా ఉన్నారా?
నెంబర్ 21/11. నాన్న పేరు పట్టు, అమ్మ పేరు గోపిక.
వాళ్ళ అక్కగారింట్లో ఉంటుంది.
ఇంకా పెళ్లి కాలేదు సార్.
మన పోలీస్ డిపార్ట్మెంట్ లో ఒక మ్యాట్రిమోనీ సైట్ స్టార్ట్ చేద్దామా?
గుడ్ ఐడియా సార్. నాకు ఇంకా పెళ్లి కాలేదు సార్.
ఇదేగా ఫస్ట్ టైం చూస్తున్నావు?
అవును సార్.
చూసిన వెంటనే నచ్చలా? ఏమా నువ్వేదైనా మాట్లాడమ్మా.
సారీ సార్.
రేపటి నుంచి ఇంట్లోనే స్నానం చేసి ఫ్రెష్ అయ్యి వచ్చేయాలి. ఏంటి?
ఓకే సార్.
ఎందుకు వెహికల్ వస్తున్నాయి? సార్ ఇక్కడ జరుగుతున్నదేంటి, మీరు చేస్తున్నదేంటి సార్?
భోజనం చేస్తున్నాను సార్.
సార్ నేను అది అడగలేదు సార్.
సార్ నాకు లో బీపీ. టైంకి భోజనం చేసి మాత్రలు వేసుకోకపోతే ఒళ్ళంతా శివరంగా వస్తుంది సార్. ఒక్కోసారి కళ్ళు కూడా తిరుగుతాయి.
సారీ సార్. కూర్చోండి కూర్చోండి. ఇదిగోండి నీళ్ళు తాగండి. చాక్లెట్ ఉంది కదా?
ఉంది సార్.
జాగ్రత్తగా పాకెట్లో పెట్టుకోండి.
అలాగే సార్.
ఏయ్ బీరో జరపోయా.
సారీ సార్.
సార్ సారీ సార్, మీరు వస్తారని శివరసేనలో చెప్పారు. దండ తెద్దామని వెళ్తే కడుతూనే ఉన్నాడు సార్.
మునుస్వామి కొట్టుకు వెళ్ళారా?
అవును సార్.
కొత్తగా వచ్చిన డిఎస్పీ కోసం అని చెప్పారా?
అవును సార్.
ఆయన మా నాన్నే
సార్. ఆయన డబ్బులు కూడా తీసుకున్నారు సార్.
ఎంత తీసుకున్నారు?
సార్ 800 తీసుకున్నారు సార్.
800 తీసుకున్నారా?
అవును సార్.
500 కూడా దీనికి ఎక్కువ. సరే చూస్తారండి, వేయండి. థ్యాంక్ యూ. ఇదిగోండి, దీన్ని ఎవరి చేతనే ఇచ్చి పంపించి డబ్బు వాపస్ తీసుకురండి. వెళ్ళండి. పద్మమ్మ ముఖాన్ని టెర్రర్ గా పెట్టుకోండి. ఇన్స్పెక్టర్ కదా మీరు?
అవును సార్.
ఎన్నేళ్ళుగా ఈ స్టేషన్ లో ఉన్నారు?
7 సంవత్సరాలుగా ఉన్నాను సార్.
క్రిమినల్స్ మిమ్మల్ని చూసి భయపడాలిగా?
భయపడాలి సార్.
నవ్వుతూ ఉంటే ఎలాగా? మొహాన్ని సీరియస్ గా
అలాగే
పెట్టుకోండి.
సార్.
బయట ఒక అమ్మాయి దగ్గర డ్రోన్ కెమెరా ఉంది. దాన్ని తీసి లోపల పెట్టి వాళ్ళ దగ్గర కంప్లైంట్ తీసుకోండి. బయట ఉన్న ఆ అమ్మాయిని ముందు లోపలికి రమ్మనండి.
అలాగే సార్.
ఎక్స్క్యూజ్ మీ.
ఎవరు? ఓవర్ యాక్షన్ వద్దు గానీ రా. నా వాడున్నాడు అంటూ ఉంటావే, ఇంతకీ ఎవరతను?
ఆ విషయం మీకు అనవసరం. చేసే ఎంక్వైరీ ఏదో త్వరగా చేయండి, నేను వెళ్ళాలి.
ఇదేమన్నా నీ ఇంటి బేకరీ అనుకున్నావా? పోలీస్ స్టేషన్. అడిగిన క్వశ్చన్లకి బుద్ధిగా బదులు చెప్పడం నేర్చుకో, లేదంటే లాకప్ లో కూర్చోబెడతాను. ఓకేనా? ఎవడా పెళ్లి కొడుకు?
అలా అంటే మీరు నన్ను డిస్టర్బ్ చేయరని చెప్పానంతే. కానీ మీరు ఊరికి వెళ్ళిన తర్వాత నేను బాగా డిస్టర్బ్ అయ్యాను. మీరు ఇక్కడ ఉన్నంత వరకు నాకు తెలియలేదు, కానీ మీరు వెళ్ళిపోయాక ఎన్నో చోట్ల వెతికాను. దాదాపు 2 సంవత్సరాలు వెయిట్ చేశాను. మా అమ్మ నాన్నల ప్రెషర్ తట్టుకోలేక ఒప్పుకున్నాను. ఇంకో 2 వారాల్లో నాకు పెళ్లి జరగబోతోంది.
సరేరా, ఇక్కడికి రా.
ఏంటి?
నిజంగా లవరున్నాడా నీకు?
అవును.
వాడి పేరేంటి?
పెళ్లి కొడుకు పెద్దన్న.
ఏం చించుతుంటాడు? నీకు కాబోయే మొగుడు గాడు.
ఆసియా ఖండంలోనే ఎవ్వరూ సాధించలేని విధంగా
மேல உனக்கு ஒரு மஞ்சம் பார்க்கும் பார்வை பரப பார்வையடா உனக்கு கீழொரு உலகம் தனக்கு தானா இயங்கு காணும் காட்சி கடவுள் காட்சியடா பூமி எல்லாம் மைதானம் பொட்டல் வழி தாம்பாளம்
ఏంటి సంతకమా కాస్తనుండే ఏ ముద్ర ముద్ర
పాలసంఘ అధ్యక్షుడయ్యండి వేలిముద్ర వేస్తున్నారేమిటి?
కొంచెం ఆగండి, మైకులో చెప్తాను. లేడీస్ అండ్ జెంటిల్మెన్ అందరికీ నమస్కారం. ఇప్పుడే అయ్యగారు అడిగారు ఏంటంటే మీరు ఏలుముద్ర వేస్తున్నారు అని. ఈ రోజు మన ఆధార్ కార్డు తీసుకోవడానికి ఏలుముద్రే కదా వేస్తున్నాం. అంతేకాదు ఇప్పుడు అందరం ఫోన్లని వేలుముద్రతోటే కదా ఓపెన్ చేస్తున్నాం. నేను స్టేజ్ ఎక్కినప్పుడల్లా ఒక చిన్న కథ చెప్తాను. నేను 3వ క్లాస్ చదువుకునేటప్పుడు మా క్లాస్ మాస్టర్ పేరు మాధవయ్య. ఒకసారి నాతో ఒక మాట అన్నారు, రే ఇకపై నువ్వు గేదెలు కాయడానికే పనికొస్తావు అని. ఆ రోజు 2 గేదెలు కొని పాల వ్యాపారం మొదలు పెట్టాను. ఆ 2 గేదెలు 20 అయ్యాయి, 20 200 అయ్యాయి. ఈ రోజు 300 గేదెలకి నేను యజమానిని. 15 లక్షల రూపాయలు ప్రతి నెల సంపాదిస్తున్నాను. అందరూ బాగా కష్టపడి బాగా సంపాదించండి. ఉంటాను, నమస్కారం.
వదిన్ని స్టేషన్ లో పెట్టారట.
ఏ స్టేషన్ రా? రైల్వే స్టేషనా, టీవీ స్టేషనా, రేడియో స్టేషనా?
విజయవాడ సౌత్ పోలీస్ స్టేషన్ లో
వచ్చారు పెళ్లి కొడుకు పెద్దన్న.
డిఎస్పీ సార్, హాయ్ డార్లింగ్, కమ్ ఆన్.
కూర్చో, ఎంక్వైరీ చేస్తున్నానుగా. కూర్చోమ్మా.
నిన్నెవరో తెలుసా?
అన్న పేరు పెళ్లి కొడుకు పెద్దన్న. ఈ ఊర్లో ఉన్న బాలకేంద్ర సంఘానికి ప్రెసిడెంట్. అంతేకాకుండా జల్లికట్టులో ఎన్నో ఎత్తుల కొమ్ములు విరిచి వాటిని ఓడించాడు. అంతేనా, ఎన్నో బంగారు పథకాలు సాధించాడు. ఇంకా ఇంకా చెప్పాల్సినవి ఎన్నెన్నో ఉన్నాయి.
ఏంటి సార్ ఇది? ఒక లేడీని లేడీ కానిస్టేబుల్ తో ఎంక్వైరీ చేయించకుండా మీ బృందావనంలో నా రాధనంతో కూర్చోబెట్టారు సార్ మీరు. ఈ రాధకి తగ్గ కృష్ణుడిని నేనే కదా. ఏంట్రా సిగ్గా? రా డార్లింగ్.
బ్రదర్.
అబ్బబ్బబ్బబ్బబ్బా, మళ్ళీ ఏంటి సార్?
పెళ్లి కొడుకు పెద్దన్న.
యా, ఇట్స్ మీ.
మీరు చూడడానికి బాగా స్మార్ట్ గా మాస్ గా ఉన్నారు.
బై బర్త్.
రియలీ?
లెట్స్ వైబ్.
యూత్
యు ఫన్నీ పోలీస్.
ముందు చూసింది నేనే మేడం.
సార్, ఫేస్ క్లియర్ గా లేదు సార్. అన్ఐడెంటిఫై బాడీ డీటెయిల్స్ కలెక్ట్ చేస్తున్నాం సార్.
ఓకే, పోస్ట్ మార్టం రిపోర్ట్ రాగానే వాట్సాప్ చేయండి.
షూర్ సార్.
హాయ్ సార్.
ఏమైంది
సార్? ఫోరెన్సిక్ డిపార్ట్మెంట్ డీటెయిల్స్ కలెక్ట్ చేస్తాం సార్. పోస్ట్ మార్టం రిపోర్ట్ రాగానే
ఎన్కౌంటర్ చేస్తావా
సార్?
సౌత్లో 6 జిల్లాల్లో స్కూళ్లలో భోజనానికి గుడ్లు సప్లై చేస్తుంటాడు కడప రమేష్.
ఇలా చూడవయ్యా, విజయవాడ, గుంటూరు, మంగళగిరి, నరసరావుపేట, చిలకలూరుపేట, సత్యనపల్లి, ఇక ఈ ఏరియాలకు గుడ్లు సప్లై చేసేది మన రవి తమ్ముడు రాజానే.
మీరు ఊళ్ళు పంచుకుంటా ఉంటే మేము గాజులు తోడుకొని కూర్చోవాలా? ఎమ్మెల్యేకి ఏమన్నా కొమ్ములున్నాయా? రారా తేల్చుకుందాం.
గుడ్ల రవి ఎమ్మెల్యే అయిన తర్వాత రమేష్ కొచ్చి ఆర్డర్స్ ఆపించేశాడు. కడప రమేష్ మీద అబద్ధపు కేసు బనాయించి జైల్లో పెట్టించాడు. పోరా. జైలు నుంచి బయటకొచ్చిన అతను 6 నెలలు కేరళలో తల దాచుకుని చెన్నై మీదుగా విజయవాడ వస్తున్నట్టు మాకు ఇన్ఫర్మేషన్ అందింది.
త్వరలో కడప రమేష్ విజయవాడకు వస్తున్నాడంట. వాడు రాగానే నన్నేడానికి స్కెచ్ వేశాడంట.
రేపో మాపో ఆ 2 గ్యాంగులు తలబడ్డాయంటే సమస్య మనకే. సో కడప రమేష్ని ఎన్కౌంటర్ చేసేయాలి.
ఎస్ సార్.
మీ టీంకి స్పెషల్ ట్రైనింగ్ ఇచ్చి ప్లాన్ చేయి.
మా టీం కా సార్?
ఎనీ డౌట్స్?
నో సార్.
కీప్ మీ ఇన్ఫార్మ్.
ఎస్ సార్. మన టార్గెట్ ని సరిగ్గా షూట్ చేయాలన్న ఉద్దేశమే ఆ టార్గెట్ మిస్ అయ్యేలా చేస్తుంది. ఇప్పుడు ఒక పిల్లాడికి బొమ్మ తుపాకీ ఇచ్చి షూట్ చేయమని చెప్తే ఆ పిల్లాడు ఎంత నమ్మకంగా సంతోషంగా షూట్ చేస్తాడో అదే రేంజ్కి షూట్ చేయండి.
గుర్రి తప్పకుండా షూట్ చేయడంలో పెద్ద కిల్లాడిలా ఉన్నావే.
కానీ నెక్స్ట్ రౌండ్ పరిగెడుతూ షూట్ చేయాలి. రెడీ?
సార్ నాకు డౌట్ సార్, పరిగెట్టేవాడిని నేను నిలబడే షూట్ చేయలేను, మరి పరిగెడుతూ ఎలా షూట్ చేయగలను?
మనం నిలబడి షూట్ చేస్తూ ఉంటే పరిగెడుతూ ఉంటాడే క్రిమినల్. ఇప్పుడు క్రిమినల్ నిలబడ్డట్టు ఊహించుకోండి, మనం పరిగెడుతూ షూట్ చేయాలి.
దయచేసి నన్ను కన్ఫ్యూజ్ చేయకండి సార్, షూట్ చేస్తాను. ఎక్కడున్నాడు సార్?
తిరిగి చూడండి.
ఉన్నాడా సార్?
బ్లాక్ కలర్ పెయింట్ కొట్టాడు చూడండి.
ఇప్పుడే షూట్ చేస్తాను సార్.
సూపర్ సార్.
అరే స్ట్రక్ అయినట్టుగా ఉంది.
సూరయ్య ఏం చేస్తున్నారు?
సార్ యూజ్ చేసి చాలా కాలం అయింది సార్, అందుకే స్ట్రక్ అయింది.
అలాగా?
అవును సార్.
తుపాకీ తుడిచారా? ఎక్కడెక్కడ తుడిచారు?
ఇక్కడి నుంచి ఇక్కడ వరకు రోజు కొబ్బరి నూనె పెట్టి తుడుస్తాను సార్.
ట్రిగర్ దగ్గర?
అయ్యో దీన్ని తాగితే పేలిపోతుందని కొండవీడు చెప్పారండి.
కొండవీడి సినిమా ఏది అటువైపు గురి పెట్టండి.
క్షమించండి సార్, ఇంకో 2-3 రోజుల్లో రిటైర్ కాబోతున్నాను సార్, నన్ను వదిలేయండి.
సూరయ్య హోల్డ్ ద పొజిషన్. టైట్ గా పట్టుకోండి.
yes sir.
గెట్ ద టార్గెట్.
yes sir.
ఫైర్. షూట్ చేశారా?
చేశాను సార్.
ఎక్కడ షూట్ చేశారు?
గురి తప్పింది, పక్కదానికి తగిలింది సార్.
అయితే మీరు పని చేయండి సార్, ఇక పైన పక్కదాని మీద టార్గెట్ చేయండి. అప్పుడు మీ టార్గెట్ తగులుతుంది.
ఓకే సార్.
థ్యాంక్ యూ. వెల్కమ్ సార్. ఎక్స్క్యూజ్ మీ, నాకు నమ్మకం వచ్చింది ఇప్పుడు మీ మీద.
చాలా థ్యాంక్స్ అండి.
మన టీం కి అవార్డు ఖాయం.
Given that the petition under 161 remained pending for 2.5 years following the recommendation of the state cabinet for remission of his sentence and continues to remain pending for over a year since the reference by the governor, we do not consider it appropriate to remand the matter for the governor's consideration. In the absence of any other disqualification, the exceptional facts and circumstances, exercise of our power under 142, we direct that the appellant is deemed to have served the sentence. Deemed to have served the sentence. In Kuldeep, Malas.
This is again an individual matter.
No, but individual matters. Well, I want to say one thing. If your lordship were to limit time limits for individual cases, it will mean, consider this purpose. In fact, the correct way is to give a timeline.
No, there could be different factual considerations, different aspects.
What it will mean is, correct. But Malas, in the case of a constitutional exercise of power under 200, 201, what it will mean is, we're talking only of 201, I have to travel either up the ladder or to the Supreme Court. The process of notice, counter, rejoinder in individual cases will itself take at least a year or 6 months. In some cases, more than a year. Your lordship's original timeline, which has already been violated, after which I'll come to the court, case to case will not solve this problem. In a general case of 200, 201, keep that in mind, Malas. These are bizarre. For example, Malas, this was case in Kuldeep Kumar was a case where in a mayoral election, I had occasion to assist the court, Malas. The returning officer can be seen on the video looking over his shoulder to see what to do with the vote. This is that case. So your lordship deals with individual cases also. But a 200, 201 necessitates a general timeline, whatever it be. Because it is not that your lordship's intention that I keep coming back every time to your lordship in an individual case.
What happens if the timeline is not followed?
Well, there is always the case. Your lordship's arms, ears, and power is large enough to see that it is followed. That's the first answer. There are always cases, but the lordship knows aberrations. Is Supreme Court versus timeline not followed?
We laid on the timeline.
Yes.
And then my brother asked a very correct question.
Yes.
So then what? So what will happen? If it is an administrative order,
yes.
If for non-compliance, it might become invalid.
No.
What is to be done? In
that's why.
Flexibility provided as soon as possible is a constitutional norm. But when a matter goes to the court, somebody says the large time has already been taken, then it becomes an individual list. There the court will exercise any kind of power, even 142 power, individual.
Correct.
But to say we will set set a
now
time
your lordship is not dealing
provision is the difficult.
My lord is not dealing in those cases with a standard paradigm 200, 201. 200, 201 as a structure. First come as assent, then return, then first proviso, then presidential reference. A general timeline is amenable to the structure of 201 is the first answer. 2. The second answer is, without a general timeline, my lord...
Lord has to amend the constitution basically to incorporate all these timelines into the provisions of section 200 and 201.
So therefore,
otherwise you come with your individual cases, if you have a problem, it will be dealt with accordingly.
Therefore, we come back to the 6 arguments in my timeline section.
What in individual case, a particular person agreed or a particular party agreed can go on Article 226 also.
Of course it can. I am saying, Malas,
But laying down a particular, there could be different exigencies, different situations, warranting different timelines for different enactments. But then providing a fixed timeline.
now Malas, let me answer that. Your lordship is dealing only with 200 and 201. Actually, only with 200. 200 structure, the first answer is completely amenable to timelines. Number two, my lord is dealing with a contemporaneous reality situation of huge delays. To have a person then travel up the ladder or deal in the Supreme Court is adding to the timeline and rendering the object behind this whole exercise nugatory. That's answer number two. Answer number three, your lordship has not asked me, brothers. There has to be an amendment of the constitution, of course. That's the ideal thing. All these examples I am giving, purposive interpretation, teleological interpretation, Manipur case, Telangana case, are cases where in the unoccupied silences of the constitution, your lordship felt the necessity to intervene.
There also we did not lay down a particular timeline for all the things.
Therefore, Malas, I know.
In the facts of that case,
right?
Like in Kesham, the
That's
court,
why
the court refused to follow Rana.
So I'm answering individual questions individually. Malas.
And in Kesham, the court fixed a timeline of 3 months.
My lord, first.
Also in Telangana case, we have a timeline of 3 months.
My lord recognizes that despite no constitutional amendment, your lordship does fix timelines. Now the question arises, is your lordships in the context of 200, should it be following a case-by-case approach, which means a bill-by-bill approach? A bill-by-bill approach, if my lord was to follow in 200, then well, the very object of putting a timeline will be defeated. The very object of putting a timeline will be defeated. That is not so in those other cases. My lord found a particular aberration in some cases. My lord dealt with it. In 200, the very object of doing a time, otherwise lordship did not do a timeline at all. The timeline object is to have a guidance which is adhered to. And the answer to my Lord Justice Vikramnath's question, Justice Narasimha's supplementary question, assume that the lordship gives a timeline and is not followed. Firstly, the correct approach has been taken in the division bench, and lordship is not judging the correctors otherwise, that there is a consequence attached to it. The consequence must be deemed assent. If you don't follow a Supreme Court, the other consequence could be contempt. A third consequence could be some other consequence, Malas. Now, we are not interested here in discussing contempt against high personages, especially with 361. But what is the object my lord is trying to achieve? My lord is achieving an object that you are given by the constitution a formal power of one return. You are given the power of reference. In both those, 3 months is more than enough. If you still don't do it, and you don't refer to a 143, a 143 is not included in the time limit, and you don't refer to a precedent, then a deemed assent is a solution.
143 prima facie appears to be, you are imposing upon a precedent that whenever
No, that I
whether the president does not have a machinery, the president can take an advice of the attorney general or maybe others to find out whether the constitutional.
No, I'm not saying that.
But,
Great respect.
But saying that the president ought to take an advice for.
Chapter is over. I have conceded. I have clarified.
But you are again now referring to
No, it's not at all. I am saying that the timeline is followed by deemed assent. 3 months is enough for all the timelines given is the first answer. Now, if 3 months are not enough, there is another option of referring to the precedent.
Flip side of it.
Yes.
Even court also grants. Suppose court somebody might say that this limit is actually too small. You please revise it. Give me more time.
Yes.
So then for that, because when we prescribe a time limit, then either of the parties must come to us to relax, like a medical college. Please relax the time.
Every week we receive so many letters from the district judges or the trial courts that the court has fixed so much time for
First of all,
concluding the trial. So we get first letter due to A reason, B reason, we cannot conclude the trial within 3 months, grant extension by 6 months. Again on second occasion, we grant extension by 9 months. So,
first of all, it has never deterred your lordships from having a time limit nevertheless. It imposes discipline and immediacy on the situation. Secondly, in extraordinary circumstances.
Governor take action within a reasonable period.
Well, it's reasonable
See a
period.
timeline which
Well, it's reasonable period and as soon as possible has been a constitutional mandate for whatever 70 odd years. Your Lordship has seen the result.
Dr.
Such
Singh,
cases have arisen when because not followed.
as soon as possible, is that not good enough?
It is proved not good enough.
Is
It has proved not good enough. Otherwise, there will be no case. My Lord is right. Why is this case come? Obviously, because it did not prove good enough.
Then this time
A lot of your lords.
persist. You are assuming
No, Malas, it will not.
time limit and this
Malas,
problem will
it
never
will
happen.
not because the deemed assent is the further follow-up which the bench has wisely thought of in advance.
Why only deep assent? Then this court should actually enter into the shoes of the governor and see all the three options, A, B, C.
That's not the same thing. It will not be the same thing. It will not.
Why only deep assent?
No, Malas.
It could have been otherwise also.
My lord,
the options are there with the governor. Then this court will exercise any of the three options,
kindly see.
either withholding or referring it to the president.
withholding and then fall
Referring to
through.
the president.
Fall through.
Kindly see. Would that be the same option? That will not be a correct analogy. For a simple reason.
Why should
Your
only
lord-
that option remain that only assent?
Your lordship, your lordship, for example, suppose my lord had taken my chart of 20 bills. Not that your lordship has taken it and seen the delays.
Dr. Singh, again,
Is your
you are
lordship going
facts
into it?
of the case. So therefore, what the Chief Justice also said, and we are also trying to, individual cases can always be examined. You come here, look here, 3 months have passed, 4 months have passed, 6 months have passed, nothing is being done by the governor.
Yes. Well, may I say, these
There is
cases,
an urgency in the
that
matter.
was the way these
Either the
cases-
governor will respond and say that this is the reason why
That
it is
was
not
the-
being done,
that-
or the court will consider what to do.
that was the way the
Examine
case-
the bill and accordingly take a
that
decision.
was the way the cases were born. The Tamil Nadu, the Kerala cases came in that fashion. It is found that this inordinate delay is repetitive, endemic.
Correct. So 142 can
entrenched.
be exercised in individual cases where necessary.
No, well, let's kindly see.
Why do you want to
your
put the
lordship
timeline into the
exercises-
constitution?
If your lordship starts exercising this in individual cases of 200, then the very purpose of timeline is gone. There's no point exercising it because the time by which your lordship's mandamus comes, worse still if it's a 226.
No, with council's
no,
pressure, you will get your decision in
I
2
think
months.
my
3
lord
months.
is not in a.
Yes.
My
And no
lord is
state
not
government
in
has come here to
ivory
engage.
My lord is not in a.
From the Canary, they will be engaging. Dr. Singhvi, Mr. Simple.
We are
Subramaniam.
thankful. We are thankful for the left-handed
Dr.
compliment.
Shankaran
But well, it doesn't work in practice. Your lordship is certainly not an ivory tower. Your lordship knows the reality better than we do. All the things your lordship is saying don't happen on the ground. Frequently don't. My lord deals with this situation only when this kind of situation arises. Otherwise, after all, for all these years, my lord did not have. Now, the real point my lord is asking is, if we have done it, if I may reformulate my lord's query and answer it, the fact that we have done it in 5 different paradigms which I am giving, we may do it in this case also, but in individual cases, not as a general timeline. That's the question put to me. All the rest of it, I've answered. I can't re-argue the whole thing. The answer to this question is simple. A paradigm of a 200 delay, which is on the record of legislative assemblies from 1400, 1200, 1800 days in innumerable bills. That's over 3 years, over 5 years, is not met by either a 226 in an individual bill case. There are hundreds of bills passed by the assembly, or a 32, if I'm lucky enough to sustain a 32 in your lordship's court. It takes minimum of a year. If it's a 226, takes minimum of 3 years. Then what's the point? The governor then has 3 years. You have then become a pocket veto, a killing of the bill, a super chief minister, and you are in effect, your lordship's timeline is not only too little, too late, it has no effect at all. So your lordship's fellows would have to decide that this case arose in a context which is nothing but 7 different paradigms I've given. This Kuldeep Kumar is the 6th paradigm. Only thing is, your lordship dealt with that case. It doesn't at all mean that your lordships can't give a general timeline. That's the submission. And the basic argument is that your lordship's fellows would be defeating the very object for which your lordship is undertaking this exercise. The initiative by my lords to give a timeline, even in that individual case, will be defeated if it is limited to individual cases. Now, Kuldeep Singh I have dealt with. Rajendra Rana was another case which was mentioned when I was arguing in the pre-lunch session. The speaker is a persona designata. only the person who is the speaker can decide 10 schedules. This is not the timeline case. It's an interesting case. The speaker is a persona designator. Nobody but him can decide the case. So technically, your lordships must remand back. And remand back by a provision of the 10th schedule, which is not a statute, it's a constitution. My lord said no. We exercise 142 and we decided.
Again, in an individual case.
That's true. I
finding that it had a checker history.
Well, it's individual case, I've answered the best of my ability.
There are two petitions. First one for disqualification on the ground of defection, and the second one on the ground of split. The High Court, the Speaker first decides the split without deciding disqualification.
That's right.
The matter goes to before the High Court. One remand.
So 145.
Second remand, then it goes to before a full bench. The Chief Justice takes a different view. The other two judges take a different view. Then the matter comes to the Supreme Court. 2 months are left.
But, Malas,
2 months are left, and the very fact that the court finds that the letter addressed by those 13 persons that we are supporting Mr. Mulayam Singh to form the government itself is sufficient enough to encourage disqualification, and therefore exercises 140.
Therefore,
it doesn't say that hereinafter in all matters the Speaker shall decide the matter in 3 months.
That point is well taken, Malas. I've answered it to the best of my ability already. And let me add, Justice Joseph's judgment in the Election Commission case is an example of a general timeline. In addition to what I've answered, I have said that a general timeline is the most appropriate response to a 200 structure. I have said that without giving a general timeline, the very object of your lordships giving any discipline of time is defeated if your lordship asks me to go to 226 or 32. Those are the two answers I've given. A third answer is at page 594, Anup Baranwal, which my lord has noted, where the learned judges gave a scheme for selection. That's a substitute for a timeline. It's a counterpart for a timeline, saying that there is no occupied field. Anup Baranwal at page 594, page 115 internal. The fourth answer is this. If your lordships, Millers, were to consider not giving a timeline except in individual cases, it will mean that all the principles of providing a teleological interpretation, a purposive interpretation for the contemporary realities, it has to be a general. A contemporary realities and felt necessity has to be a general panacea. Well, the answer cannot be that your lordship will wait for timelines which will exceed, well, court delays are endemic in this country. Supreme Court is the fastest court. To get a final decision in matters like this, well, it will not take less than a year. Realistically, let's say 6 months, 7 months. Before that, the time which he has kept it back is already held. 7 months is supersonic speed. I did the Punjab case. I did the other 2 cases. It didn't take less than that. So therefore, the entire purpose of timeline goes. They are the only 5 answers as to why, Malas, your lordships should not do the case by case. There is no 6th answer. If your lordship is looking for a judgment which gives a timeline generally in a constitutional matter, the closest is the Election Commission matter. Anup Baranwal at page 115. And Keshav gives it, no, my lord is saying it's an individual case. That's the whole point. My lord says it's an individual case.
Court gave a direction in 3 months.
In 3 months, speakers of
That's what his direction was.
So across Malas, 10th schedule, where your lordships can again, it can be distinguished. It's a tribunal.
Tribunal and
everything.
All the constitutional benches hold that the Speaker does not enjoy the immunity under 112
But
and 112.
The 3-month guideline is a general norm for 10th schedule after the judgment. You may not follow it. The consequence is not given.
There are only 2 cases, Keshav and Telangana.
Telangana. No, that's it. I'm coming. So therefore, no, first case is.
General law, neither Keshav nor laid down. On the contrary, in Telangana, we hold that it is high time that the parliament should revisit.
I'll give you the citation.
We say that it is again within the domain of the parliament.
Therefore, Malas, a combination of a timeline coupled with a consequence is the best answer for the felt necessity of the time. Now, Malas, page 152 is 145. Is article 145 at page 152. (155), the short answer is, it lasts from 152 to 159. That was only those substantial questions of law which are not which are not decided, may be referred. Not if it is decided is the real answer at para 155 at page 152. Well, in this Abdul Rahim, they say that a substantial question as to interpretation ceases to be that if it is already decided. If it is already decided, it ceases to be a referable question. And bottom of page 153, it is clear that no substantial question of law as to the interpretation arises in the present case, as the very question raised has been decided by a bench of this court consisting of 5 judges. So there is no question of reference if your lordship finds it decided.
So, the decision by 2 judges of this court.
No, that's the next para. That's coming. It's the next page. Next page. Nobody's saying it's final, Malas. It can be referred by the same bench. I am answering the question. The same bench need not refer it where it feels, which it has done here. That is decided. I'm saying there's no error. They can refer it. A bench always refers to the lordship. Or in a fresh case, X versus Y. The same question decided in A and B can be referred. Yes. Then
back to the, just 1 minute.
Yes.
Coming back to the previous question that we were deliberating upon.
Timeline.
Timeline. Now, the consequences of the timeline have been provided that there will be deemed assent. So the assent is granted by the court. Now, if a bill is granted assent, it becomes law. Right? That can be challenged on the ground of being ultra vires or whatever the provision.
Yes.
That will again come to this court.
It will come on the
merits.
merits.
You grant assent.
It will come on the merits, Malas. Nothing to do with the lordship assent. Deemed assent is a process
just
which
is
given to.
So this court
My
becomes
lord
part of the legislative process, and then that deemed assent can be challenged by way of a writ petition.
Now, may I answer that? May I answer that? One, your lordship is in no way part of the legislative process. By judicial decision, your lordships would have held, if your lordship upholds, a timeline with a consequence of not following a timeline, which is a judgment of a court, a law of the land under 141, 142, 143, 141, 142. 1 minute. Second answer. After having so given a judgment on the law, today it's a division bench judgment, tomorrow it will be a 5-judge bench judgment on some of these questions. Your lordship doesn't whisper a word about the merits of a bill. In this entire adjudication or in that adjudication, not a word is it constitutional or unconstitutional. My lord is fully empowered.
Then there's that option which the governor has, A, B, and C in the substantive provision of 200.
Yes.
Is not exercised at all.
No, it is exercised.
No, by whom?
No, Malas. With respect.
Because he has
not exercised in 3 months.
Act in time.
Not exercised.
So therefore, there is a deemed assent.
In that case, then your lordship will have to say that he can just hold it back as much as he likes. That's the only other answer.
That's a different question.
No, there are only 2 options, Malas.
That's a different question.
Yes.
The question is whether a general timeline could be.
No, that's
while we exercising powers under 140.
As I understand it, my lordship Vikram's question is a little different. That question, your lordship, that's one part. His question, my lord's question is
with regard to the deeming assent.
2 things. No, 2 things. But my lord is asking 2 questions. You becoming a part of legislative process, and then you judging the bill, the act. That's my lord's question. Well, those are completely non-contradictory. My lord is becoming nothing but a part of the judicial process, not a legislative process, by holding that timelines are necessary by whatever purposive interpretation, teleological, felt necessities, whatever. Having so held, and the timeline being expired and a deemed assent happening, my lord will look at something totally different, the merits of the bill, if and when challenged. There is no contradiction. And my lord doesn't mix up any separation of power issue. Nothing.
All right.
Now, this verse is the section on verse 145. In fact, ironically, one of the bills in the Tamil Nadu list, which was part of the other division bench, is directly under challenge before my lord's Justice Vikramnath's bench, where I am arguing. Your lordship gave a date last week, some other date about some university UGC. Mr. Mehta is opposing. So that exercise my lord does is not part of a judicial function which happened already. That's a different judicial function. Now, last point, an important point. Come to page 160. So the answer to 145 is there is no question. If the division bench thinks that it is necessary, it may refer. It is not obliged to refer if it finds it's already decided. And a second bench can always refer the same question, but leave that and come to the last and most important point, which will take 5-10 minutes. 160. Now, first see the question. This question has been reformulated by Mr. Mehta, 160, and it is not the president's question at all. 16, please, 1 minute. 160. This is the president's question at 160. Does my lord have 160?
Yes.
Does the Constitution bar any other jurisdiction of the Supreme Court to resolve disputes between the union government and state governments, except by way of a suit under 131? So, I am going to argue it both ways. It doesn't directly say does 32 barred by a state. But I am assuming he's right. I'm arguing it both ways. I'm assuming that he's right to raise the question. I'm saying textually as put, it is not raised. I'm arguing that other point also. So first, just give me 3 or 4 minutes on 131, then I'll come to 32. So first, just see 131. The present, so only I'm on 131. The present question does not and cannot arise as 200 cannot be brought in the scope of dispute between the government of India and one or more states or between 2 or more states. For a dispute to be construed as a dispute under 131, such dispute has to be between the government and one or more state or 2 or more states. This is not so, where a governor is involved. That's the short answer. Then, I've quoted in the other paras, ornamental functionary, guide, philosopher, and friend. Come to 165.3 at 161, Justice Krishna Iyer in Maruram. Because the precedent is symbolic, I'm only answering 131, Central government is the reality, even as the governor is the formal head and sole repository of the executive power, but is incapable of acting except on and according to the advice of his Council of Ministers. Then 162, the constitutional conclusion is that the governor is but a shorthand expression for the state government and the president is an abbreviation for the central government. The next singles case, it's a constitution bench. The governor has a dual role. The first is that of a constitutional head of the state, bound by the advice of his Council of Ministers. The second is to function as a vital link between him and the union government and the state government. In certain special emergent situations, he may also act as a special representative of the union government. He is not union government. He is not state versus state. He is not state versus union. That's the point being made here. He is required to discharge the functions related to his different roles harmoniously. He is not an employee of the union government, nor the agent of the party in power, nor required to act under dictates of political parties, etc. Then state of Karnataka points out, the article is attracted only when the parties to the dispute are government or one or more states. And then, we quote that. I'll skip that, Just see the next page for a minute. The article is a necessary concomitant, 164, 164. Article 131 is a necessary concomitant of a federal or a quasi-federal form of government, and it is attracted only when the parties to the dispute are the government of India or one or more states. This is a limitation as to parties. The other limitation as to subject matter flows from the words if and insofar as the dispute involves any question of which the existence or extent of a legal right depends. So these two concurrently have to satisfy 131. It is certainly not satisfied as to parties in the present case. Then 166, where state of Karnataka in another para is quoted. In an ordinary civil suit, the rejection of a right asserted by the defendant cannot correspondingly and with its own force establish the right claimed by the plaintiff. Proceedings under 131 are adjudicatory of the limits of constitutional power. Middle of that page. The competition in such a proceeding is between 2 or more governments. Either the one or the other possesses the constitutional power to act. A demarcation and definition, so it's only state and government, and governor will not fall, is in brief what I'm saying here, I leave this, I've come to the end. Now, I'm answering the question why Article 32 will lie. Though it is not quite so framed, I reread the question in favor of Mr. Mehta to say that since 131 can lie, other forms like 32 are excluded. I don't think that's the question, but I'm always rereading it against myself. The answer is, Malas, in a very short 2-page note in volume 2.3, which I filed after the man and 2.3 or to register to 2-page note, and I'm done. My first submission is the article's focus is not on 32 at all. Sorry, the query's focus is not on 32 at all. Your Lordship need not answer it. Your Lordship need not answer it. Second, 131 doesn't bar. Now the third answer on 32. Come to Malas, page 1, para 2. Murugan's case. Page 1, para 2. May I read, Malas? On the question of maintainability of the writ, according to learned Solicitor General, the same cannot be permitted to be raised in this reference, since the said question was not raised and considered in the order of reference reported as so-and-so. This, Malas, note down, is a writ by the Union of India. This matter which your Lordship is reading in my para 2 is a 32 writ by the Union of India. Then the bottom of that same page. Since the issue raised in the writ cannot be worked out by way of a suit under 131, and since the accused are private parties, the writ is the only remedy available. Now let us just pause. 131 is not applicable in my case. Now there is one government and a governor. I've come in 32. Apply the analogy. Come to page 2 now. Page 2. Having considered the objections raised on the ground of maintainability, having heard the respective counsel on the said question, having regard to the nature of issues which have been referred, we are also convinced that answer to those questions involve substantial questions of law as to the interpretation of 72, 73, 161, 162. This is the second answer. Substantial question of law involved, Lordship should hold it to be maintainable, as various entries as well as corresponding provisions. We do not find it appropriate to reject the reference on the technical narrow ground of maintainability, is answer number 2. Then, Malas, this is a state filing of Article 32, is para 3. In state of Uttar Pradesh, where I believe Mr. Mehta appeared, they filed a combined 32 plus 406. But 406 is a substantive provision. 32 is the modality. Modality was 32 only. Transfer of accused from Punjab to Uttar Pradesh under 32. It is next page 3. It is submitted as a writ petition filed by the state is certainly maintainable under 32 for the reason that the administration of criminal justice is bestowed upon the state on behalf of the victims of crime and also on the premise that a crime against a citizen is a crime against the state. I am asking your Lordships to underline behalf of the victims of the crime and also on the premise that a crime against the citizen is a crime against the state. This is the larger parens patriae public interest jurisdiction. This is what I am canvassing for my Lord's consideration as my submission. This is the argument of the state of UP through Mr. Mehta. Not that there is any estoppel against him. I am not suggesting it at all, just like there is none against me. To maintain the petition under 32, learned counsel placed reliance on Sriharan. Next para. It is further submitted in any event this court may invoke 142 for doing complete justice. Now, whereas in the written submissions, of course, they say in the next para that it, in as much as it is filed under 406, it is maintainable at this instead of the state. Now, 406 is the substantive provision for transfer, not the modality. The modality is 32 only. Now, Mr. Uttar Pradesh's submission, it is submitted to this honorable court in the aforesaid judgment. Now, this is the written submission filed in that case by the state in Article 32. Entertain the petition filed. There existed a dispute between center and state. In the present case, state, the dispute is between two states. It is submitted there exists no explicit or implicit bar for filing a petition under 32 by the state. Then, the most important concluding paragraph where I put it together on the concept, and that is para 7. 7. May I read 7 minutes? This is the overall conceptual part, and then I'm done. The case is cited after that. Further, the parents patriae doctrine empowers the state government to be a custodian of the fundamental rights of its citizens, enables it to take all necessary steps to safeguard it. There are diverse facets to this submission. A bill is the sovereign expression of the state acting in public interest for the welfare of its citizens. Secondly, When a state challenges egregious delays by the governor, it seeks to promote public interest of each citizen of the state. Thirdly, this exercise inherently seeks to promote and protect the fundamental rights of each state resident citizen. Fourthly, when the state so acts, it is acting for the collectivity of its inhabitants and additionally exercising parens patriae. Lastly, none of these facets would be excluded from part 3. The case for this is Charan Lal Sahu Malas. The first sentence is parens patriae. They start. And the next page is, this court also recognized the concept of persons relying on parens patriae. Then Malas, they completely discuss parens patriae, which I'll not read, but the entire jurisprudence is given and quoted by me over Malas 5 pages. I've underlined Malas. It saves time if I don't read it. But parens patriae is Malas, the jurisprudence explained, elaborated how it evolved, what are the limits. I certainly say, Malas, that in view of para 7, the 5 reasons I've given or the 4 reasons I've given, you have a collectivity, Malas, of public interest and parens patriae, which would make this petition. And indeed, the state is otherwise remediless. This is not a 131 dispute. You always can say go in a 32, in a 226. That's a different matter. But that is not the object, Your Lordships. 226 alternative does not bar your 32 in any manner. Your Lordship may not entertain a 232. It never bars you. I'm extremely grateful, deeply obliged. Deeply obliged. I'll join in shortly.
Yeah, I got it. I got it. Because I'm appearing for the state of West Bengal, Malas. I was to also appear for Karnataka, but if I do that, my learned friend will not get time to address your lordship. So I'm giving up, Malas, and ask my learned friend to appear for Karnataka. Malas, may I just broadly tell your lordships what my submissions are going to be, because lots has already been said, Malas. So we'll need to encapsulate, Malas, our submissions so that everybody gets a chance to argue. Whereas what is your lordships considering today? If you look at 200 and 201, the first question you have to ask yourself is, what's the nature of the power exercised by the governor in 200? Is it legislative? Is it executive? What's the nature of the power exercised by the president in 201? When the matter goes to him for consideration. Is that on the aid and advice of the Council of Ministers at the center, or is it his personal power? Those are the two fundamental questions that your lordships will have to ask yourself. I'll assume for a moment, Malas, that it's an absolute executive power. Let's assume against myself. So consider this, Malas, a conundrum, which is a constitutional conundrum that your lordships will have to face. A legislature in a state is reference to a item in list 2, say distribution of electricity, or an exclusive item in list 2 passes the legislation. That's the will of the people, and that's a sovereign act. So your lordships will have to come to the conclusion to decide against me that sovereign act of the legislature need not be implemented by the executive. He can withhold it. So for the first time in the history of constitutional law in this country, your lordships would hold that the will of the people need not be implemented because the governor chooses to withhold the bill. It's a proposition, Malats, which is unaccepted under any principle of constitutional law. It cannot be. Why, Malats? Now let me give your lordships why. If you look at the theme of the Constitution throughout, in respect of the executive chapter, Malats, in relation to states, or the executive chapter in relation to union, you will find that the executive at no stage has any legislative power. If it comes to the executive in the union, Mullards, the president will act on the aid and advice of the Council of Ministers. President has no individual function. When it comes to the state, Mullards, the governor will act on the aid and advice of the Council of Ministers. The governor has no individual function. If at all, the governor has two functions, Mullards, which are somewhat different under the Constitution itself, which is 356. But that's a recommendatory function. It's not a decisive function. The governor will recommend that the functioning of the state is such that that cannot function under the provisions of the Constitution. Who decides? The government of India. Who decides finally whether that's right or wrong? Your lordships. So you have to address that question first, Mullards. Let's forget about case law. Fundamental constitutional law. 356 is one such power. 161 is grant of pardon, again, exercised on the aid and advice of the Council of Ministers. And 311(2) is another power. 311(2). Inquiry not necessary to dismiss a government servant because of the satisfaction of the governor. Again, on the aid and advice. Give me one provision in this Constitution, one, that allows the governor to exercise any power which thwarts a legislation. We'll come to timelines later, but at the moment, I'm not concerned with. So you have in 200, in a part of 200, a power to allow the executive, namely the governor, who doesn't have to act on the aid and advice of the Council of Ministers. He doesn't consult the union government because he has no right to consult the union government, but he will just withhold the bill. Well, such a proposition is untenable from any standpoint. Point number one. Two, what choices does he have? Let's now assume, Mullards, in my favor. I assumed against myself, Mullards, and made my point. Let's assume in my favor that he has no power to withhold. Where do we go from here? He then has to either send it back. Now, Dr. Singhi made 3 alternative propositions on that, but I'll not go into that for the moment. He has one possibility to send it back to say that you reconsider the bill or you pass the bill with certain amendments. That's what's reflected in the first proviso, right? And that he has to do as soon as possible. Or he sends it to the president for his consideration. That president means the government of India, not president in his personal capacity or her personal capacity. That's the only 2 options he has. Now, Mullards, if he exercises the first option, namely he sends it back, let's assume he exercises that option, he has to do it when? As soon as possible. Mullards, please reflect on the word possible. It's not just soon. What can a governor have an impediment on not to consider the bill forthwith? He has no impediment. He's holding a gubernatorial office. The will of the legislature is reflected in that bill has come to him. Certain DA allowances are to be given to somebody, or that will be a money bill. But if it's a non-money bill, some in the field of education, something has to be done. In the area of reservation, as your lordship knows, under the Right to Education Act, and these are state acts now, you can reserve for certain categories of individuals. Supposing the government wants that children or orphans should also be included in the reserved category. Children or orphans. I'll give an example. So how long will the governor have to take for that? When you say as soon as possible, what would be impossible for the governor to hold it back? That too, your lordships will have to consider. Forget about the timeline for the moment, Just look at the words of the Constitution. Timelines will come later, Let's look at the other scenario. That the matter is sent to the president for consideration. Now, what did the president do? As soon as possible doesn't apply to him.
So in sending it to the president, there would be an advice of the Council of Ministers?
No. That's not my argument.
We just wanted to know.
Well, that's the argument of Dr.
State that as to whether it is to be sent to the president or not.
No, correct. I'll tell your lordships.
Yes.
I'll tell your lordships. What will happen in the process is that he feels that this may be repugnant.
Therefore, he is applying his mind.
He has to, that's not my, Doctor. I'm not following Dr. Singhvi's argument there. He has to apply his mind.
So deal with the aid and advise aspect of it first.
I'm sorry?
Aid and advise aspect of it, and also the aspect relating to discretion.
I'll come to
that.
this.
The governor first, because after answering that question, then the second issue will arise.
Yes, yes.
He has absolutely no discretion at all.
As far as the aid and advice is concerned, when it comes to the right of the governor to send it back, there is inherent evidence by reading the provision itself that he does in his capacity as governor, feeling that it might be repugnant to a central legislation.
Takes his own call.
That's my
That's not based on aid and advice.
It can't possibly be. It can't possibly be.
Completely contrary to Dr. Singhvi.
That was the first alternative of Dr. Singhvi's submission.
What we have
That he suggested that everything has to be on the aid and advice.
So normally, because a bill before it is presented to the legislature would come to the cabinet.
Presented to the governor. No.
Before the bill is.
I'm going to come to that.
Unless it is a private bill.
Right. I'm going to come to that. That's a second proposition, brought at the moment. I'm not dealing with the article, We're just broadly giving your lordship the submission. Your lordship is right, That's the other thing. The basic principle of constitutional law in matters of this nature, when there is interaction between the executive and the legislature, is that there must be a level of amity and cooperation to make the constitution work. Your lordship sitting, in this court has to ensure that you interpret the constitution to ensure that it works.
Correct.
Not that it does not work. Not that the governor says, I will not allow this to go forward.
25 years of
exactly.
Constitution.
Exactly.
He has worked.
Exactly.
As if it has
exactly.
worked.
Right. In no principle of constitutional law which allows a breakdown of constitutional machinery. There is no such principle of constitutional law. These are fundamental mullahs that the court will knows and looks at mullahs when deciding a provision. So mullahs, you can't have a situation where the governor says, I just sit back, I don't want to do anything. What is to be done thereafter is a separate issue, mullahs. But if you look at 200 carefully, you will find that the governor will either send it back with amendments, with suggested amendments, or he'll send it back for reconsideration. And then the legislature will then pass it if it feels that it should be passed. Now, if the first stage is on aid and advice of council of ministers that he'll send it back, there's a question of if it will be passed then. There's no question of if the legislature feels it should be passed. That's what 200 says. So there is inherent evidence in 200 itself that that little exercise of power is by the governor.
So what considerations weigh with the governor when he takes a decision to send it
Well,
back
that's right.
or not to send it back?
Correct. I appreciate that.
That's the pathology of decision making as against that of an executive.
But that
Where
decision making is not adjudication.
Our question is that what's troubling us is that when he takes a decision of this nature, is it a logical, syllogistic, or a court type of a logic that he would follow? Or are there any considerations like deliberative, consultative, or any other methodologies by which he will have to apply his mind to send it back?
Well, let's take an example. I appreciate what my lord. Let me take an example. Forget the governor, the president. Well, many a time bill comes to the president. Well,
President's position is completely different. We're not at the president, we are governor's position.
No, I'm answering that. In the light of what my lord is asking, giving an example, because the president has taken the advice of the attorney general on several occasions, even if the bill is with him. Correct. So similarly, but he can take advice of the advocate general saying, this is what I feel, there's a problem with this. What do you think? He can do that. He can take the advice of a private lawyer. The president does it. We've seen it in action, Mullah. The president is not exercising his personal, the president is just considering, Mullah. He's not just a rubber stamp ultimately.
There have been instances where even senior counsels have been considered.
Yes. Therefore, my lords you ask me this question, the answer is simple. He is not taking any decision. After all, he has a mind, he's the president, he's the governor, he has a mind of his own. He will genuinely may believe that there is something that needs to be addressed. He is not the decision-making authority. He doesn't act as the judge. He can't reject the bill. He has no power to do that. He can't withhold it. He can either send it upstairs, Malad, or he can send it back to the legislature.
You are only on the issue of withholding?
Yes.
Are you only confined to withholding?
No, I'm saying withholding, Malad, my broad answer, and I'll take your ships through Malad, the details.
No, that's right.
I'm the other one. Withholding, he cannot withhold. Malad. That question doesn't arise of withholding because he'll be overriding the will of the legislature. It's anathema to the Constitution. There's no question of withholding. The question is, if he is not withholding, what then are his options? That's the point that I was trying to address at this point. His options are either to send it to the president or send it back to the legislature. Legislature with suggestions, right? By exercising a limited amount, because it is as soon as possible. By exercising a limited amount of application of mind, should I send it back or should I just give assent to it? And if it does send it back, Mullah, the legislature passes it and it's cleared. That's the law. Right. Now, Mullah, he sends it to the president. What's the focus there? What will the president do for his consideration? That's the last line of 201, Mullah. What does that mean? Can he sit? Because there the president is the council of ministers. There the president has no leeway like the governor does in 200. So can the government of India sit on the bill? It's the executive again. What principle applies to the government of India? As soon as possible. So there is an element of urgency. Why? Because the legislature is sovereign, and a legislative act of the sovereign cannot be withheld, must be passed as soon as possible. And there's no impossibility in dealing with it. So if your lordship says forthwith, that's enough. We don't have to say 3 months, 4 months, 6 months, 8 months. Forthwith. Because that's the nature of the exercise. That's what, now, Malas, as my Lord the Chief Justice mentioned to me, what happens, Malas? What happens in Parliament? I've gone through it several times over, Malas. If I want, if a department of the government of India wants to introduce a bill, what happens? Malas, the department prepares a draft and circulates it to all the ministries who may be effective. It's something to do with fertilizers, they'll circulate it to the Ministry of Health, Ministry of whatever. And Malas, then what happens is that after comments will come, and then comments will be collated, Malas. Then ultimately some kind of final draft will be made, and then it is sent to the Ministry of Law. And then the Ministry of Law will look at it, Malas. And then ultimately a bill is drafted in its entirety, and then it goes to the cabinet. Now, if the bill has really no problems with it, it'll pass, it'll be passed. But the cabinet may think, no, this is a matter which needs to actually go to a group of ministers. Why I'm giving your lordships that this is what happens. It's a collaborative exercise of the executive, ultimately resulting in the introduction of the bill. Right? So that collaborative exercise is done by the executive.
Machine learning engineering is a
So it's
popular
not as
choice
if
in today's
the
career
legislature
landscape.
is going to pass a bill in relation to foreign affairs. The kind of examples, Manoj, that were given by the solicitor. Manoj, I can't understand this logic. My learned friend says, don't deal with facts in the cases that are before other courts or in these states. But I'll give you facts that I will deal with. You can't have it both ways. He is given assumptions, or he's given any number of facts. He argued that, Manoj.
He said, in such matters.
What such matter means what? Facts. He is now assuming a fact, creating a chimera, then arguing on logic that, look, if this happens, what is the poor governor to do? So you can't have it both ways. He can't give examples of that nature which have not happened in the history of this country and of parliament and of the legislature since independence. And those are the examples that he has given, and he's made an argument on the basis of that. He can't do that. If he is to argue it, he must argue it bereft of such, sorry, I don't want to use a harsh word, such example. So, therefore, the president too, and the president here is the government of India, must act and deal with the bill as soon as possible. Now, let's assume, Malas, that my learned friend's argument is right, that the governor acts in his own capacity. Because if your lordship knows, Malas, the argument of 361, Malas, that is being made. And that's a very interesting argument. If you look at the judgments of the court under 361, you will find this. When it comes to 356, governor doesn't have to be made a party. Because the order is passed by the government of India. So government of India will defend the governor. That's why you say government need not be made a party. If it comes to Malas 161, again the governor need not be a party. Why? Because the order can be defended by the government. If it comes to 311(2), again the governor is not a party because it will be defended by the government. But if it's the government's own power, the government cannot defend him. So, apropos the debate that took place with Dr. Singhvi, if you were to challenge that order, Malas, the governor will say, I cannot be asked. And there will be no government of India to defend him. So the 226 cannot be filed. If you hold that withholding consent is an absolute power of the governor. It will lead to absurdity. It will lead to lack of function of the Constitution itself. Whereas this Constitution, its genesis is in history, but its alignment is with the future. And who decides the future of this country? U5, in this case. The future of India is at stake if you give such powers to the governor. Because it will lead to these absurd situations. And even 361 is wrongly read, Malat. If you look at 361 carefully, and I'll come to that tomorrow when I deal with it. If you look at 361 carefully, you will find this. The first part of 361 says that he is not answerable. Then it goes on to say, but he can be impeached. He can be removed. And then the proviso comes. The gravamen of 361 is to make sure that he will not be answerable to an act. Just read 351 with me. It's very interesting. And it's not been interpreted like this ever before with us. Yeah, just let's. If I may, Malat, with your Lordship's permission.
Yes.
The president or the governor or Raj Pramukh of a state shall not be answerable to any court for the exercise and performance of the powers and duties of his office, or for any act done or purporting to be done by him in the exercise and performance of those powers and duties. Then a colon. Provided that the conduct of the president may be brought under review by any court, tribunal, or body appointed or designated by either House of Parliament for the investigation of a charge under 61. Provided further that nothing in this clause shall be construed as restricting the right of the person to bring appropriate proceedings against the government of India or the government of the state, which is 356, 311(2), and 161. There the government will answer. But if it's the governor alone, it can't be. This proviso will not work. No criminal proceedings shall be instituted or continued. So much as your lordship sees, removal provision is in the proviso. Criminal proceedings is in subsection, sub-article 2, and no process of arrest is against sub-article 3. And no civil proceedings shall be instituted during his term, whereas if it's defamation or something like that, will not be done till the term is over. So you have criminal proceedings, civil proceedings, to which he is completely protected. But not for an official act, according to me, Malas, not for an official act. Not for an official act in which, Malas, the government of India can defend him.
Rameshwar Prasad looked into all that. Rameshwar Prasad's...
Correct, but the true import of 361 is really immunity from personal attack. That's what it is. That's what really 361 is all about. He's answerable. He's in every respect, he's answerable. But answerable not in his personal capacity, but by the government. Because it's the government which actually takes the decision. But if you interpret 200 in this way, it will not operate. You will not be allowed to operate, Mulaj. Because how will I file a petition against the governor? But the governor acts on my aid and advice, Mulaj. So who will stand up for the governor? Government of India can't stand up. Government of the state can't stand up.
Interestingly, there's no provision.
It's very, very interesting.
Second to Article 70. 21, if I'm not wrong.
Similar to 61.
No provision similar to 61. That's correct.
61 for the government.
Correct. Absolutely.
So therefore, because if the appointment is by the union, by the pleasure of the president.
And Willis, look at his oath of office. Look at the oath of office of the governor. It's very interesting, Willis. Kindly see. Which 160? No, oath of office.
That's the reason why they won't stand on a different footing, president and the governor.
No. 150. Very interesting, Willis. Kindly have a look at this oath of office, which my learned friend read. And I'll show you, Willis, the difference between that.
159.
15. Very interesting, my lords. I so and so. Sorry, my lords. Solemnly affirm that I will faithfully execute the office of the governor or discharge the functions of the governor, name of the state, my lords, and will be to the best of my ability preserve, protect, and defend the Constitution and the law. And I will devote myself to the service and well-being of the people of the state. Just read the oath, my lords. 159. That is very interesting, my lord. He owes his allegiance to the state, which gives you an indication, my lord, as to what his constitutional responsibility is. And if you differentiate with the oath taken, my lord, by ministers, it's very interesting, my lord. See that. Huh? Third schedule, my lord. Very interesting.
As compared the
Yes.
to the people of and well-being of the people of India.
Give it to me. Yes, ma'am. Yes, it says. The oath of the minister says, I will bear true and solemnly affirm faith and allegiance to the Constitution of India. There it is, defend, preserve, and protect. Preserve, protect, and defend. Which means he has no actual role in the functioning of the government. Here it is, owe allegiance to the Constitution of India as by law established, that I will uphold the sovereignty and integrity of India, because he is the sovereign himself, so he will not take that oath, the governor and the president, that I will faithfully and consciously discharge my duties as a minister. That oath will not be taken by the governor because he has no duties to discharge. He's only a constitutional titular head. As a minister for the union, and that I will do right in all matters of people.
Faithfully execute the office of governor or discharge the functions of the governor.
Correct. And three further, my lords, that I will do right in all manner of people in accordance with the Constitution and the laws. Because he is actually the executive delivering the will of the legislature to the people of the country. He is the vehicle. The executive is the vehicle to uphold the will of the people reflected in the legislature, which is a sovereign act of the legislature. That's why the nature of the oaths are different. Where it is preserve, protect, and defend. That's partly an answer to my Lord's question, just Narasimha's question, as to what does he do if he thinks that this bill, something is not right with this bill, because he has to preserve, protect, and defend the Constitution. He may think there's something wrong with it. So these are indications of the nature of the responsibilities of the governor. So forget the word veto. And whereas the third aspect your lordships have to consider also is, what do you mean by discretion? There is no concept like discretion in 200. Where is the word discretion used in 200? Is either withhold assent, grant assent, refer it to the president, refer it to the legislature. Where is the discretion? The whole argument was made on discretion.
Discretion either to do one of these three things.
No, my lords, no. Discretion is advisedly used under 163(2) by or under this Constitution. Read 163(2), my lords, with respect, with me. One or both. Lightly see. There shall be, I'm sorry, just read 163(1), 163(2). There shall be a council of ministers with the chief minister as the head to aid and advise the governor in the exercise of his functions, except insofar as he is by or under this Constitution required to exercise his functions or any of them in his discretion.
Therefore, if you say that in 200, he does not need the aid and advice of the council of ministers to take a decision whether or not to grant, withhold, or refer it to the president, reserve it for referring to the president, or to send it back, then he is exercising his discretion.
That your lordships are now using a word of art to understand what exercise of power. No, but that's a constitutional duty. I'm sorry, Mullah. That the governor is exercising a constitutional duty in his discretion by or under this constitution. Kindly come to 671A. Just come with, read with me.
Let us understand the.
Yes. Kindly
Be clear on that.
I'll straight away, Mullah, indicate to your lordships the argument. 371A.
How does he take the decision on what basis? One application of mine?
By or under his discretion has been explained, Mullah, thoroughly in Navam Rebia. Please, I'll demonstrate that, Mullah. 371A. What does discretion mean in 163(1)? By or under the Constitution?
Yes.
Kindly come to 371A. It says, notwithstanding anything in this Constitution, no act of Parliament in respect of religion, leave that out. Let's kindly come to B. The governor of Nagaland shall have special responsibility. Now note this, with respect to law and order in the state of Nagaland. For so long as in his opinion, internal disturbances occurring in the Naga Hills Swinsang area immediately before the formation of the state continue therein or any part thereof, and in the discharge of his functions in relation thereto. And the governor shall, after consulting the Council of Ministers, exercise his individual judgment as to the action to be taken. Now the proviso, provided that if any question arises, whether any matter is or is not a matter, as respects which the governor is under the subclause required to act in the exercise of his individual judgment, the decision of the governor in his discretion shall be final.
This is correlates 163(2).
163(1).
No, 2. Sabarticle 2, 163, Sabarticle 2, identical.
It would be final.
No, but that's been interpreted. I'm sorry, Your Lordship, that's been interpreted in Navan Rebia, that 163(2) there is no individual power of the governor at all. I'll show you the passage to Navan Rebia. Therefore, Mullah, by and under this constitution is 371A, 371H. And why, Mullah? It relates to law and order.
Particular.
Yes. Your lordships are putting to me this question rightly, that also can be in his discretion. But that's not the meaning of 163(1). That's a constitutional right or power or duty or whatever you may call it. The same, and this also, this is quite executive power. Kindly notice this. 371A is executive power. It is not legislative power. It's quite law and order. Just like 144. When somebody comes, what if 144 should be imposed, or this should happen, or that should happen? What do you
Part of the expression there in the proviso, which says, which is very uniquely worded.
Yes.
Under 371A, clause required to act in exercise of his individual judgment.
Yes.
Which is very, very different from that of Subarticle 2. Subarticle 2 almost identical, except that it doesn't use in the first part in exercise of his individual judgment. But rest of the article is one and the same.
Correct. Now, this argument was made in Navan Rebia by counsel saying that 163(2) is the power which allows the governor to use his discretion. And that was in the context of what, Mullah? In the context of summoning the house. Your lordships remember in Navam Rebia what happened was that the governor, Mullah, summoned the house without the aid and advice of the Council of Ministers. He summoned the house, then he said, this is the agenda of the house.
Right.
This is going to be the agenda of the house. Then he said, this item should be the item which should be voted first in that agenda. In that context, the argument made by counsel for the governor was that 163(2) is his individual judgment, gives him that right. Court said nothing doing, right? That is only by or under this constitution relating to specific articles of the constitution. 371A is one of them, referred to in Navan Rebia. So there is no such thing as discretion in Article 200. It's completely alien to 200. Now, having said that, you will also have to understand, and your lordships will have to probably reflect over it, even if there is discretion under the Constitution to be exercised by the constitutional authority, there are contours within which he must exercise or she must exercise that discretion. That's not the free will of the governor, that in my discretion I will withhold the bill. That will be struck down immediately. That discretion has to be exercised in the contours of the concept of discretion.
The concept of discretion under sub-article 2, though repeatedly said, it is subject to those which are specifically provided in the Constitution. Just wait.
Yes.
In the Constitution, invariably, all those arose and got identified by virtue of interpretation of the court. So we have by the court a process by which we have identified and said this is a specific constitutional provision by virtue of which it can be said that it is a discretion vested in him by virtue of the Constitution.
Right.
So it is in that same line that we will have to see it's an inquiry by the court whether 200 keeps a kind of a discretion in it or not. It's an inquiry. And constitutional larger principles, as you have indicated, in principles such as democracy, principles such as the federalism as adopted in state of Punjab's case, are guiding principles on the basis of which you would see and interpret whether such a discretion exists or not.
Well, my humble submission to your lordship says that discretion is a concept alien to 200, and I will try and make that good.
No, discretion as indicated.
No, but your lordship is saying that you will have to see as a matter of interpretation whether that concept can be incorporated in 200 as a matter of interpretation.
Discretion as have been provided in the Constitution is the expression in sub-article.
With by or under?
By or under.
No, but it is not by the Constitution.
They have not identified those specific.
They have,
concepts right here.
it identifies them. 239.2, 239.2, 371A, 371H. 200 is not there. 200 is not there.
Yes, we're right. We are on that point.
So therefore, the point is, it says by or under the Constitution. Shamsher Singh majority says the same thing. The point I'm making is, why do you want to incorporate something that clearly is not there in the Constitution? And if you were to exercise, he were to exercise or she were to exercise that power of discretion, what is the... If he or she were to exercise that power of discretion, what are the contours reflected in 200 by which that exercise can be done? None.
Therefore, again, the same question, Mr. Simple, how does the governor take a decision under 201? First,
well, I tell your lordship the problem there.
And I've
reflected on it for a long time. I'll show you why. Now read 200 with me.
Yes.
For a minute. The problem that arises, and for your lordship too, you may even reject my argument, but there's something to be said for that. Kindly see.
We want to understand whatever.
Yes. Now see 200 with me, brothers. Read the proviso. I now assume that the government will aid and advise the Council of Ministers, the government and aid and advise the governor. I'll assume that now, before he sends it back.
I put you that question earlier, whether the governor acts on the aid and advice of the Council of Ministers while taking a decision under 200. You said no, correct?
No, I said no, wait the amendments only.
Council of Ministers.
Wait the amendments.
Taking that decision?
Now kindly see that. Read with me.
Either you
read
that he is acting on the aid and advice of the Council of Ministers.
Read the proviso with me for a minute, further. Read it.
The proviso, the main part, the first part.
All right, I'll read. When a bill has been passed by the Legislative Assembly of a state, or in the case of a state having a legislative council, has passed the bill by both houses of the legislature of the state, it shall be presented to the governor, and the governor shall declare.
Governor shall
also my question not been answered. What does declare mean? Your Lordship, my Lord Justice Suryakant asked the question, not been answered. I'll try and answer that. Declare either that he assents to the bill, correct? No problem. Or that he withholds assent, no problem. Therefrom, or that he reserves the bill for the consideration of the president, correct?
How does he take any of these three decisions?
Just see, read the proviso. I'll come to that just now. For a minute. Let me answer this. I'll answer what my Lord is putting to me. Read the proviso. Provided that the governor may, as soon as possible after the presentation.
This is not a mandatory requirement for him. It may, if he grants assent, then there is no need for the proviso. The proviso becomes irrelevant then. So, or if he reserves for the president, then also the proviso is not relevant at
Correct.
this
Now,
stage.
let me answer that.
How does he take the decision
All
of
right.
whether reserving it for the president or granting assent or withholding it?
So there are two interpretations to that. Number one, that
On whose advice and who?
Yes, exactly.
Either it is his own wisdom.
That's right. There are two interpretations. That's why I'm saying either the government of the day tells him reserve it for the consideration of the president.
Then is on the aid or advice of the.
Yes, that's Dr. Singhvi's first alternative argument.
Said no.
I say no. I say no. Of course, it's my argument. No, because if he's going to refer it to the president on aid and advice of council of ministers, why would the bill be sent to him? So therefore, it's obvious. Well, this is obvious. It's a no-brainer, well, according to me. Therefore, there is an element, not of discretion, of a constitutional responsibility.
That's right.
That's what I'm saying. Now, read the proviso with me. It's interesting. Provided that, I wanted to liven up the proceedings, therefore I'm not reading through judgments first.
Yes, yes, that's right. It's more interesting.
Provided that the governor may, as soon as possible, after the presentation to him of the bill for assent, return the bill, and if it is not a money bill, together with a message requesting that the House or Houses will reconsider the bill or any specified provisions thereof, and in particular will consider the desirability of introducing any such amendments as he may recommend in his message, and when a bill is so returned, the House or Houses shall reconsider the bill accordingly, and if the bill is passed again. Now you read the word if the bill is passed again. Malad, if the bill is returned on the aid and advice, where's the question of if the bill is passed again?
Then again,
So therefore, I am not agreeing with the first argument of Dr. Singhvi, Malad. This is it's my case, Malad.
Then how does he write his message? That also, I guess.
That's therefore there is that play. That's that constitutional responsibility. After all, as I said, he's not a postman. There, I agree with him. There is some play in the joints.
You agree that he's not a postman.
He's certainly not a postman.
Correct.
Certainly not a postman. But there is that limited play in the joints. What is that play? If he feels that this requires the consideration of the president, he can consult lawyers, he can consult and refer it to the president. Or if he feels that some amendments are required, or that's a suggestion because he's not the deciding authority. So he sends it back. That's perfectly workable. That's what makes the Constitution work. If it's only on the aid and advice of the Council of Ministers with no leeway, what's the point of having a governor then? Then how will it work? It will only work through a collaborative exercise of constitutional authorities.
The correct word.
That's how we must interpret the Constitution. Otherwise, Malas, yes. Now, Malas, just see some constitutional principles. Then I'll sort of, what's the time? Enough time. Now, kindly see, Malas. As I said, no, just your lordships may just note these principles, Malas, like this, so that your lordships may. There is no principle of constitutional law.
Is there in your written note?
I can put it, Malas, if your lordships.
We have already done it.
Yes, we have already, you have got your written note.
Initial.
No, Malas, that should be effaced, Malas, because Malas, what happened?
Only it has been uploaded.
Just now.
Yes, sir. The same one.
The same.
2.4.
2.4.
Make some propositions which are new.
Which are new.
The reason is, Malas, when I introduced that particular note, I didn't hear the learned Solicitor General's arguments. So I have to really deal with, very serious arguments made by him. So I had to make a new note.
Yes. And also, we did not have the benefit of hearing to Dr. Singhvi's argument.
I also didn't have the benefit of that.
1.4. 1.4 is 2.4 is
2.4, Malas. 2.4 are my submissions. This is not included. Not included. I'll include it. But let me read it then. I'll read them and then I'll include it. It says there is no principle of constitutional law which allows for a breakdown of constitutional machinery. So this blanket, I will not withhold consent, is just not on. Two.
So I will withhold the consent endlessly.
Endlessly. Okay, just not on. It is anathema to the Constitution, the very concept of withholding assent. Timeline is a different issue. I'll come to that.
You cannot sit over the wisdom of the legislature or the.
That's right. Two, each organ of the state must function to ensure that it does not act as an impediment in the functioning of the other organ. That's the second principle of constitutional law.
No organ can impair the functioning of the other.
Exactly. And in the context of separation of powers, you can't argue that the executive has a legislative role to play. It's anathema. How can you argue that? It will go against federal principles. Of course, we have a new definition of federalism, which your lordships also will consider. Three, the working of a constitution is a collaborative constitutional exercise. It's not combative. This is as if it's combative. I will withhold it. It is non-justiciable. So you cannot even ask me. That's a combative position, not a collaborative position. Any disputes in respect thereof requires the Supreme Court of India to be the final arbiter. While interpreting the Constitution, the fundamental premise of a court is to ensure that each pillar of the state under the Constitution exercises powers in accordance with the provisions thereof and discharges its duties as provided for within the constitutional framework, not outside it. While interpreting the Constitution, the court must, as a matter of principle, lean towards interpreting the words therein to allow for solutions to make the provisions of the Constitution workable and not lean toward the constitutional interpretation that makes it unworkable. And no organ of the state has absolute power. That's the other very, very sound constitutional principle. No organ of the state, neither the legislature nor the
executive nor the judiciary.
No, only one absolute power, master of the roster. That's absolute power.
That's power.
That's absolute power. Nobody can challenge it.
That is done with great amount
In a lighter way. In a lighter way.
Done with a great amount of restraint.
I don't take it amiss. I just said it in a lighter way. I agree. Since your lordships put it to me.
I have only now 2 months or something left. It's a message for 3 of them.
And I have definitely not heard what you asked.
I am far away.
Miles to go.
Forget by the time your lordship really have heard.
Then the next is responsibilities of all organs of the state functioning under the Constitution must be guided by the principle of preserving, not thwarting the democratic process. They must preserve the democratic process. And a judicial interpretation of the Constitution cannot nullify, defeat, or distort a constitutional provision by so interpreting the Constitution as to prevent an act of the executive from not being amenable to judicial accountability. You can't interpret and say, this is not amenable to judicial accountability because I have some absolute power. And constitutional provisions are required to be interpreted and understood with an object-oriented role that Dr. Singhvi has already mentioned. And when interpreting the Constitution, which is meant to endure the test of time, given the stresses and strains of changing circumstances, the court's approach should provide for a workable resolution consistent with the object underlying the constitutional provision. So these are broad principles. They are supported by judgments. I'll add it in the note for your lordships. Now let's have a look at let's now go to the provision itself. Kindly come to my note. Yeah. Now, the other thing about justiciability, which the other argument brought, I'll just indicate what my submission is going to be there. My learned friend's submission was that I am not saying there's no judicial review. All I'm saying is just not justiciable. It's just not justiciable because there are no manageable standards. That's what he said. There are no manageable standards to make it justiciable.
Unlike 356.
Unlike 356. But Mueller's 356 has the word satisfaction. Your Lordship knows 356. It is the satisfaction of the governor. 311.2 is the satisfaction of the governor. Now, satisfaction implies an element of subjectivity. And therefore, in Boma and other cases, your Lordships have held that, look, we will go thus far, but no further. That's absent in 200. There is no subjective element there. Therefore, the nature of the exercise of power under 356 and under 161 and in 311.2 is qualitatively different from the nature of exercise of power under 200. Therefore, those principles just cannot apply. Whereas what are judicially manageable standards are normally in the basic in the domain of the executive. Normally in the domain of the executive, not in the domain of the legislature. Because legislative acts will be challenged in a court of law on violations of Part 3 or other lack of competence. So they are all judicially manageable standards. Take Article 14, Malas. Does Article 14 have a definition? No. But it's manageable. What is equality? You'll have to decide on a case-to-case basis whether equality has been violated or not. But that's manageable. Why? Because there's a fundamental principle of equality that runs through the Constitution itself. Arbitrariness cannot be defined. Liberty cannot be defined. Yet it is manageable because it has constitutional implications on freedoms. Well, how do you say 200 has no manageable standards? What's the relevance of that? All standards which are not manageable are in the domain of the executive. What kind of crowd shelter should be? Should the court say you should pass directions that puja should be held here and not there? This is not manageable. This procession should not move in this direction or that direction. Not manageable by the court. But that's executive responsibility. But in the area of legislative responsibility, all standards are manageable because it's on the touchstone of the Constitution. Whether it's lack of authority, lack of competence, or violation of provisions of the Constitution. Therefore, this whole argument that it is not manageable, for example, let's take, for example, because I think it's a rule of evidence, actually. Manageable standards, not being able to manage standards is a rule of evidence because you don't have any evidence to actually manage it. Take, for example, a communication between husband and wife, solicitor and client. There are no manageable standards to deal with it. That's a rule of evidence. Because the court doesn't have the wherewithal, doesn't have the facts in its possession to be able to manage the situation. That's a rule of evidence. You don't have enough evidence. That's far removed from 200. Yes. Yeah. Just put it, I don't know how to resolve this. It's a difficult thing to do. All right, whatever here. Now, let us kindly have a look at 2.4. This one, page 815.
Volume 2.4.
2.4.
Big number 815.
Yes.
Small number
815. Page 815.
Small number 3.
There is no small number 3. It's better the other way. Oh, that's fine. Mhm.
Yes. We are utilizing the time for some other purpose.
No, I understand that. Well, let's kindly come to page 3, or rather 815, internal small page 3.
A big 815, small 3.
Yes. The constitutional premise for interpreting provisions is grounded in, though not limited to, constitutionalism, separation of powers, federalism, reasonableness, and democracy. And under the framework of separation of powers, the legislature legislates, the executive implements, and the judiciary adjudicates upon disputes relating to both ordinary and under the Constitution. This basic premise does not allow the executive to exercise primacy over lawmaking. The executive must function under the consistent limitations upon it by the Constitution. 53(1) of the Constitution states that the executive power of the Union shall be vested in the President and shall be exercised by him either directly or through officers subordinate to him in accordance with the Constitution. Now, whether this is the executive power will vest in him and be exercised either directly through officers subordinate to him in accordance with the Constitution. The officers also cannot act outside the Constitution. Therefore, this is the power to execute legislation. That's what it means. That's all that they are obliged to do. They can't thwart legislation.
Power to formally executive.
Yes, formally, naturally, formally.
But there lies some discussion with them, with the governor, that for some reason it may withhold and send it back to the legislature.
Yes.
With a message.
Again, you are also using the word discretion. That's the moment you said that. That's his obligation.
Obligation. All right. Obligation.
Yes.
That's the option he has to exercise.
He has to constitutionally exercise that option.
The word discretion is a problem for them.
No, it's not a problem, Malaj. What happens is, once you use, this was used loosely in other judgments, which is what has created the problem. For example, it is said 239(2) is a discretionary power. It's not.
You may say so, it's not discretionary that he has option A and B.
No, that's a constitutional obligation again, 239(2), because he'll run the government with us through the union. He's a lieutenant governor. There is no, what's the discretion there? The concept of discretion is alien to 239(2). But yet this court, in passing, uses the word discretion with us. So this is what happens if you use the word, then you start interpreting.
Takes a decision.
He takes a decision.
Takes a decision.
That's right. That's what he's doing. That's his constitutional right or obligation. That's all I'm saying. What happens is if you use it, then in other cases when matters come up, they say the constitutional bench used it in this fashion, so use discretion. This is what happens.
But then that decision taken by him, whether it is justiciable or not.
Which one?
The governor's decision under 200.
Certainly not. If he assents to the bill, it is certainly not.
Of course, it is.
He takes
no decision. The act is to be challenged.
200, he takes.
Or if he reserves this for the president.
That's not his decision. It's a recommendation.
That's his decision to.
No, Malaj. This is again a fallacy as a matter of law.
He may reserve it for the
opinion. I'm sorry. It is a
justifiable reason.
Decision and element of
challenge.
A decision is an element of finality. It is opinion that this requires reconsideration of the president. That's all.
Declaration he has to make that he is reserving it for the president.
That's right.
Whether that declaration is justifiable or completely unjustified and unwarranted.
Well, first of all,
whether it can be challenged or not.
It can never be challenged.
It can never be challenged.
It can never be challenged. No question of it being challenged.
That's what the other side is also.
But that's there's nobody has ever challenged it, Mullah. Again, that's a chimera. Who has ever challenged it? He has also said assent is justice.
On your side, there are arguments which are conflicting or contradictory. You are taking a different stand. Dr. Singhvi took a different stand.
No. It's only on one point I'm taking a different stand with Dr. Singhvi. That's on the first. We're agreed. Yes. Yes, we're agreed.
We'll hear them when
it's only on
they have a different stand or not.
But Mr. Shankararan said that he is on a middle path.
No.
Both sides.
Both sides.
That is not justifiable.
Not just, how can assent be justiciable, Manoj? And who has ever...
assent will not be justiciable once he grants it.
But that's the
law.
argument made, that way assent is also justiciable. That's an argument made. Nobody has ever said that assent is justiciable. Nobody has ever said that if you send it to the consideration of the president, that is justiciable. Nobody has ever said that. It's nobody's argument. It's been never argued in any case. It's something that he has assumed and said, even that should be justiciable. It's not our case. It's nobody's case.
On one point, you are together. On the same page.
Which one, Mullah?
That is not justiciable.
Mullah, I am Kamath, Mullah. How can you be together with him? But he is not
Yes.
Baba Sahib. I may be Kamath.
Mr. Kamath used to oppose everyone.
And who is Mr. Naziruddin Ahmed?
Naziruddin, yes.
No, Mr. Kamath, he did not oppose everything. It was Mr. Naziruddin Ahmed who opposed every suggestion of Dr. Ambedkar.
But Mr. Kamath used to oppose others as well, particularly Dr. Ambedkar.
So this principle is contained in the oath taken by the president, as I've already shown that here. Oh, sorry, Malas. 5 is that in accordance with the Constitution necessarily means that the executive power is exercised by the president is not absolute, as must function within the limitations and in accordance with the processes of the Constitution. In other words, the exercise of executive power must be in alignment with the Constitution. Then 6, this principle is also contained in the oath taken by the president. Well, I've already shown that to your lordships. Then paragraph 7. Once Article 73(1) and 162(1) define the executive power of the union and the state respectively. Under 73, the executive power of the union shall extend to matters with respect to which Parliament has power to make laws. So it's limited to list 1 matters. And Mullahs, under 162, the executive power of the state shall extend to matters with respect to which legislature has the power to make laws. But it has no legislative function in that. Under 73 and 162, it is clear that the power to make law is vested exclusively in the legislature, and administrative power of executive is coterminous with legislative power. Further, both provisions begin with subject to the provisions of the Constitution. That's very important for us. So that executive power is also subject to the provisions of the Constitution. So therefore, that act of the executive will be subjected to scrutiny. And if it transgresses executive power, it will be struck down. So you cannot interpret the transgression as a power which allows only one provision in the Constitution, withholding consent, would be executive power that overrides the legislature. Goes against the very fundamentals of parliamentary democracy. Then under 74, there shall be a council of ministers with the Prime Minister at the head to aid and advise the President, who shall in the exercise of his functions act in accordance with such advice. The provision stipulates that while discharging his functions entrusted to him under the Constitution, the President must act on the aid and advice of the Council of Ministers. My learned friend also conceded when we were interpreting 111, if your lordships will remember, that when Parliament makes a law and sends it to the President, he has no power to withhold.
No, he can send it back. Once.
That's all. But that's the very power here.
Once he can withhold.
Yes, but the word withholding consent is there. But there is no absolute power there to withhold. So how is it, that withholding consent he has no power, but the governor has? It can't be, See 111? That very expression is there. Yes. When a bill has been passed by the Houses of Parliament, it shall be presented to the President, and the President shall declare either that he assents to the bill or he withholds assent.
And thereafter the proviso?
And then it's provided that the President may as soon as possible, same thing, So therefore, here withholding consent is not absolute, no absolute power to withhold consent. But the interpretation is in 200 he has that absolute power. So the same expression used in two articles would be interpreted differently by this court. That's what my learned friend wants your lordships to do.
The difference in the executive power.
Yes, it's the same thing. And Mullahs, kindly see, I'm not that now that I'm in that. Read 200 once again with me. It's very interesting. The second proviso to 200. It's very interesting. Second proviso to 200. I'm digressing a bit, Mullahs. It just occurred to me. Sorry. Provided further that the governor shall not assent to, but shall reserve for the consideration of the President any bill which in the opinion of the governor would, if it became law, so derogate from the powers of the High Court. Shall not assent to.
Yes.
Different from withholding assent. It's my learned friend's argument, withholding assent is shall not assent to. No. Permanently. Second.
So according to you, where an absolute power was intended by the Constitution,
yes,
not to give assent,
yes,
this specific mention has been made by the Constitution.
That's right. That's right.
In the Constitution.
In the Constitution.
Therefore, that can't be added in the first proviso.
Absolutely.
Or in the main.
That's correct. The concept of withholding is itself a temporary concept. Withhold, send it back. Withhold, send it to the President. Right? That act of withholding is an act
for that. These two options.
For that only. I'll do it tomorrow, Mullahs, now.
There was a request from your side that somebody wanted to, I think from state of Himachal Pradesh. Who is that? I think was
Himachal, it's not Madhya Pradesh.
I think
we are giving him time, We'll give him time.
He has a personal difficulty next week, so he wanted some precedence tomorrow. That we'll have to be considered.
I will. He's an old colleague of mine.
You deal with him.
Yes, I can't deal with him. He's elder to him.
Some marriage in the family, and I was.
Yes. Mr. Sibal appeared for West Bengal.
No. For Himachal Pradesh, Mr.
No. Mr.
Sibal appears for West Bengal, yes.
He has given up Karnataka.
Because otherwise, my colleague Subramanian Swami, Gopal Subramanian Swami, he's also a colleague, so that's all right. He will not get time.
Do you want him also to come here?
He would have, except that he's some difficulty. Obliged, deeply obliged.